I think items 21 to 24 are now before us, and I've been advised that the Leader of Government Business proposes to start off consideration by a cognate debate, leading off a cognate debate. Items 21 to 24.
Yeah.
Order number 21, sir, to name of the Honourable Leader of the Senate to move the second reading of the Severance and Unemployment Validation Bill 2018.
Thank you, Mr. President.
Yes.
First of all, I want to seek leave to be able to consider this matter as a cognate debate, inclusive of items 21 to 24. I think all honourable members would recognize that they're all related, and they seem long, but they're all fairly straightforward matters, and I believe should not take up a considerable amount of time. Although I know that my colleague in the opposition, this is his special area, so I will certainly be considerate and give him as much time as possible to expand. The bill speaks to the Severance and Unemployment Validation Bill. And I think honourable members will recall that in 2015, I believe it was, the then government, in an effort to replenish the unemployment fund of the NIS, the National Insurance, the Severance Payment Act was amended to redirect the contributions which would normally go to the severance fund, to the unemployment fund, to refund it, because you remember that persons had been sent home then, and there were issues in terms of the replenishment of the unemployment fund. At that time, I believe it was to be from 2015 to December 31st, 2017. However, that process has continued, and as we all know, this is now December 2018. But the actual amendment was for until December 2017, hence the validation to bring it up to the end of December 2018. This matter, of course, was discussed not only with the social partners, but with the Employees Confederation at the time, and it was agreed that the rate of severance payable would move, was normally 0.5% from the employer's the taxable earnings from the employer, and that this would have been diverted to the unemployment. As a result, nothing was then paid into the severance fund. It is now being proposed that this non-payment or non-payment into the severance fund be continued, but should be discontinued, but that you will have a 50% going. In other words, the 0.5% of income, where you were diverting all of that to the unemployment fund. You would now be taking it, splitting in two, 0.25 to the unemployment fund and 0.25% to the training fund. With the recognition that with the recent separation of some persons from service, that there will be an additional burden, of course, on the unemployment fund. And of course, the Prime Minister has spoken in terms of modernizing government's operations. They would need to be able to retrain some of these people who have been retrenched. Hence the focus also on contributing to the training fund. In terms of the other matters that are covered, essentially the bill makes provision in terms of the training on, and as I said, it makes provision for that. It requires, obviously, certain changes to some of these acts that exist at this point in time. And one particular one speaks to making provision for state-owned enterprises. As it currently stands, some of those persons have been terminated, and at this point in time, they have been unable to receive either unemployment or severance benefits, as no contributions were made to the relevant funds at the time. It is proposed now that the Act will be amended so that consideration is given to that, for them to participate and contribute and also benefit. I know there's some issue of some discussion during the break in terms of government preparing for the retrenchment of persons, and this is all about them contributing over the next 2 years to their severance and to their unemployment benefits. But I'd like to allay their fears because it should be noted clearly, and we have a former chair of the tribunal, I believe, who here to advise us. Former chair? I think it's former, Mr. President. I believe that they told me that the period ended in July the 26th. But no doubt she will recognize, I haven't called anybody, Mr. President, the severance requires contributions for 104 continuous weeks, and certainly implementing this on January the 1st, we will need to get past 2020 for them to really benefit as such. So that is, in terms of that, there's no real mischief. There were queries about Water Authority and how their workers are going to be compensated or paid, and I've been assured, I've spoken to both NIS and to the Ministry of Finance and Water Authority will make their own arrangements. The intention is not for NIS to take on that burden immediately. And I believe this is something that has been discussed at the level of the social partners, etc. So, Mr. President, as I said, it is fairly straightforward. These amendments, I think we understand the process. We're continuing something that was essentially started in 2015. It was to end December 2017. It has continued. We have to do the validation of that. We're making provision in terms of additional training and the amendments to the National Insurance and Security Amendments Bill. With these few words, Mr. President, I beg to move that this bill be now read a second time.
Thank you very much, Mr. President. I'm sorry to say to the leader of government business that he's been giving some very bad information. You know, and this happens when you put the wrong people in position and then take advice from them. You know? Not you. You don't put the wrong people in position yet. I have no difficulty with the first aspect. With the first, no. I can say it here and now, because I've said it before. I've said it on the radio. She was one of the better chairs that the tribunal's ever had. And yeah, there are a couple of others too, but ever had. Yeah, but my difficulty is not with the amended, with the contributions that were changed in 2015 and 17. That was a mistake that went on too long. It was government making people pay for their own severance. You know? No, because only employers are supposed to pay to the severance fund. Employees do not pay toward the severance fund. The funds that employees pay to would be the sickness benefit, for maternity, unemployment, pensions. They pay for them. And that is why permanent government employees who are not entitled to sickness benefits or unemployment benefits pay less than people in the private sector, because government permanent workers, appointed, people call them, were entitled prior to national insurance to their sickness benefits being paid for up to a year. That's, if people want to check me, that's General Order 524-1. It says that you're entitled to your sickness benefits for 1 year, for 6 months, and if you're likely to recover, you know, if the doctors say that you will still be able to work after a period of time for a further 6 months. So when national insurance came into being, it would have been foolhardy to have a provision in your contract that says that you're entitled to your full salary if you are sick, and then government then would turn around and give you 66 to 30% of your salary as a sickness benefit. So you did not contribute toward the sickness benefits. Similarly, when Tom Adams introduced unemployment benefits, he never expected permanent employees to become unemployed. And even if they did, there was provision in the Pensions Act where they would get their pensions until such time as government finds a job for them. So you wouldn't give them a severance pay and a pension too. So they didn't qualify for unemployment benefits or severance pay. And a similar thing happened for the statutory boards, for the permanent employees of statutory boards. They also pay less national insurance than the average person in the private sector because they were not, the government would have been paying them for a full year. And national insurance pays you for a full year of, for sickness. Well, 312 days because they don't count Sundays. If you take away the Sundays from the year, you get 312, I think. And so national insurance pays you for 312 days of a year. And government pays you for a year as well. So it would have been foolhardy to pay you full salary and then national insurance. So you didn't contribute, I didn't pay. The problem that we are trying to fix is not a problem. What happened? The error was made, it started in 1975 when the then Prime Minister, the now excellent Earl Walden Barrow, he recognized a flaw in the pension system. And in 1975, he sought to correct it. And the flaw is this. If you were working in the public service, and for however long, and you did not reach retirement age, you did not get a pension. The earliest you could have retired in the public service back then was 50, with special permission. And he said in Hansard that it was unfair if you have a person working in the public service from 18 and he worked to 49. Essentially, he would have worked 31 years and he would not have been entitled to a pension based on the legislation that it stood if he left and go and work someplace else. So he proposed that if you have pensionable service in the government service and you want to go and work at some other business in town, you see better, you can get more money or whatever, he welcomed that. You go and make the more money, but we will not give you a pension. We will store your pension for you until you reach a pensionable age. That was done in 1975. And this was just a year before the government changed in 1976. You will remember that, sir.
Very well.
The pension amendment then was only catering for people who left the public service and go and work someplace else. Now it has been mixed up with people who the government sending home. The legislation was never intended to deal with people who the government are making redundant because they were already taken care of under the Statutory Boards Pensions Act at Section 10. It says here, you receive your pension on or attaining the age of 60 years. That's one condition. Section 10 of the Statutory Boards Pensions Act, Cap 384. 2, on the abolition of his office. 3, on the reorganization of his office for any purpose. Those 3 we're going to be going, then they talk about for on grounds of inefficiency or for medical, if you have medical evidence to say that you are unfit for work. So it didn't say on the abolition of your office when you reach 60. It says on the abolition of your office. It also, this provision came over from the Pensions Act for public servants because they treated the people at statutory boards and the people at the public service similarly. So if you were in the public service and your job became redundant, we call it abolish in the public service. If your job was abolished and you had the 10 years, you got your pension. But that was governed by Section 13 of the Pensions Act. Section 13(1) says, and I'm paraphrasing, if you are in receipt of your pension prior to reaching pension age, and the Governor General can call you back to service with a similar job. Subsection 2 now goes on to say, if you refuse to take the job, your pension can cease until you reach retirement age. Now the government is saying, or the people who are advising the government is saying, that you are not entitled to your pension until you reach 60. Now how is that possible? How is Section 13 possible? If you are in receipt of your pension, it can cease until you reach retirement age. That means you had to be getting it before you reach retirement age. What should have been happening to the public workers who are pensionable under the Pensions Act or the Statutory Board's Pensions Act? If you had up to from 2 to 9 years, you receive a severance payment, a similar payment to the severance. If, however, you were vested, you had 10 years service, then you were entitled to your pension. The problem came with the misunderstanding of the intent of the legislation passed in 1975 to allow people to leave the public service and store their pensions. Not people fired from the public service. It was you voluntarily leaving, going to work somewhere else to come back and get your pension when you reach retirement age. On the other hand, people who were working and the government said, we no longer have use for you, and you had your 10-year service, you got your pension until they can find something for you to do. So we have a situation where, and I can tell you what, because the circumstances that this thing happened. In 1975, this was just a little while before the government changed 76, Tom Adams was sitting in the House of Assembly. Could you imagine the government of the day proposing legislation to abolish pensions for public workers, and Tom Adams sit down and said nothing? Well, this is what you want me to believe happened in 1975, because the Prime Minister then, Right Excellent Honourable, he was the only person who spoke in that debate, but they can't call it a debate, who spoke. He rationalized it. It was a very progressive piece of legislation for public officers. So the opposition kept quiet. Let me say a word. They let pass and go on, so they made them fuss over it. Because it was, the government then, the DLP administration, they were becoming very unpopular. So you didn't want to big them up for something. So the Barbados Labour Party opposition in Parliament at the time said not a word. I'm looking for it here now to tell you exactly where to find it in Hansard. Pensions Amendment 75.
There's silence is reported there.
Pardon, sorry?
There's silence is reported there.
The Pensions Miscellaneous Provisions Bill 1975, it is found, what I'm speaking about, it is a Hansard, the 22nd of July 1975, pages 5253 and 5254. The only person to speak in that debate was, as I said, the Prime Minister at the time. And he could not have been abolishing pensions for public servants, and the opposition sit down and say nothing. It was never, this piece of legislation was never intended to cover a situation like we have now, where the government is sending home people and not paying them. I heard there was some provision as well, sir, where they were proposing to cover those people who had who had more than 10 years service and, as they claim, not entitled to a severance pay because they are pensionable, that they would give them their gratuity early, but not the pension. Gratuity is pension. It is 1/4 of your pension, your annual pension emolument, times 12.5. Why 12.5? Back in 1947, when this thing was done, they worked out that people live 12.5 years after retirement. So they give you a 1/4 of your pension and said by 12.5, and they give you that as a lump sum. And if you live over that period, you win. If not, government loss. You know, the case may be. But so gratuity is actually one part of your pension. So if the government acknowledges that they're going to pay your gratuity, they've got to pay your pension as well, because gratuity is pension. They just call it, they just take a lump sum and give you upfront, but it is your pension. So, Mr. President, I understand the well intention of the government. I am not trying to fault them here. I am just saying that the government has been given some very bad advice. You know, and when I heard it, and I'm sorry that I didn't have a lot of time to prepare for this because I only recently got it, but pardon? No, but no, I'm very sorry, but no, I needed a bit more time because the government is trying to be fair to workers based on the advice that it has. But the advice that the government had is flawed. I would have been very happy to give me advice, and for free. For free. I'm not looking for any money. My problem here is, and why I say that, because when the government do things like this, they hurt people. And these are the same people that will come knocking on my door for help. So it gives me a lot more work. So if I can get it stopped up front by the government recognizing the error, you know. Because I remember when they were talking about sending home the people from government services, they were going to make some of them redundant as well. I made a whisper to someone. I said, you know, you can't send home established workers unless you come to the House and the Senate, because they have to, under Section 13 of the Public Service Act, if you're going to reduce the numbers in the public service, that has to be done by a resolution, by an order laid in Parliament, and it's subject to affirmative resolution. So it had to be debated. That is where you get this nonsense about voluntary separation package. In a voluntary separation package, the separation packages in the public service are already legislated. If you want to change those conditions and give them more, then you have to come back to Parliament and say, well, notwithstanding the provisions of the Pensions Act or the Statute Board's Pension Act, whatever Pension Act you're dealing with, we are going to give you additional if you go home early. But you are asking people to go home and get nothing. Because in essence, what government has done is to say that we will give you, when we send you home, we will give you a month's pay and any vacation that you're entitled to and whatever else. You know the thing. Again, sir, government policy has always been, from the time I joined the labor movement back in 1980, has always been government policy that government will treat its workers no less favorably than the private sector. So if you're sent home in the private sector, you got, depending on your length of service, you can get up to 2.5 months notice money. Under the Employment Rights Act, Section 22, it is, Senator Tate. So when government is only giving you 1 month, it is treating its workers less favorably than the people in the private sector. Private sector, public service employment was always, everybody wanted to get in public service because it was better. Now, because of changes and misinterpretations, I wouldn't advise anybody to seek public service employment first. No, I'm very serious. You are better rewarded at the end if the employer take you out unfairly or wrongfully, because we have the Severance Payments Act, we have legislation dealing with unfair dismissal, and we have the Employment Rights Act that benefit people in the private sector. And I can assure you, under the Employment Rights Act, it is, an employer has to be very careful Because almost anything now, if he steps up, if he breaches the legislation, it becomes unfair dismissal. It is more difficult to prove wrongful dismissal. So I don't advise my people to go to magistrate's court anymore. I always tell them head to the tribunal. It's easier to prove because it's based on the legislation. So if you breach the legislation, the dismissal is unfair. But government has bound the statutory boards, but to the Employment Rights Act, but it has not done so for the general service, for central government. So the statutory boards are covered under the Employment Rights Act. So when government sent home a lot of these people, and they did not consult with the unions or consult with the workers, they were unfairly dismissed. And we have a case before the tribunals ruled on this one. It was QT Lynch and the National Conservation Commission, where because there was no consultation, they got paid up to another year's pay. And I think the tribunal gave everyone in the National Conservation Commission who went home another year's pay. So government is treating the workers in central government very badly. It does not benefit you to be a public servant. The next thing about the public service is that those people who were not pensionable under the Pensions Act or the Statutory Boards Pensions Act, who were on contract, they would get a 20% gratuity, because it was worked out some years ago that government pays about 25% less than what you're worth. That 25% will cover you for your pension. That is why when you go home and you're not pensionable, you get the 20% gratuity. So imagine now you have two people working in the same department in government. One doing the same job, but one is pensionable and the other is not. The fellow who is pensionable, he gets his pension at 60 or whatever time he gets his pension, but the person who is not gets 20% of the salary at the end of the year. So when government decides not to give you your pension, you technically paid for it already, because that 20% that should have been set aside for you, government never set it aside, because government never had the money to set it aside. I think the only government I know of that sets it aside is Anguilla, where they're small and they can put that money in a pension fund. Government prefers to pay pensions from current revenue, and that is where the problem comes. That's why they always think when they try not to pay people the pension, because they got the money to do it, especially in these hard times. But hard times or not, you have employees with certain conditions of service, and when the time comes, you should give them what they're entitled to. I don't understand why you are saying to me now that having worked under certain terms and conditions, I know that when I leave the service, for whatever reason, unless I am dismissed, I'm going to get a pension. And if I leave at 65 or 67, as the case may be, because pension age is starting in public service from 55 now, and go all the way to 67. But it depends when you were appointed in the public service. So if you were appointed, let's say, after the 15th of July 1984, your pension age is 65. Prior to that, it is 60. But then, the Arthur administration came, and they made some amendments to the retirement age, and they said, okay, we are not changing your conditions of service, but if you want to go, you can. But your retirement age is still 65. It's still 60, but you can go on to 65 or 67, as the case may be. We are not forcing you. at any time. And people relied on that. And like in the case of the IDC, those people say, okay, good. They said we could go on 67, we're going. And while on your way to 67, the people start in the middle and say, oh, we can send you home at 60. People didn't plan for it. So this is not you now, this is the last set who took and even tried to defend it in court. They took action against their people, hurt them. A guy's working today, and then all of a sudden you tell him, you're 60, you're 62, you might be going to send you home for the time you were 60, so you go home now. But you had given him permission to go on to 65 previously. And if you give me something, I rely on you, I promise, you give me something. I've accepted that I can go on because of your assurance to me. And then in the middle of that, you can't just take it away. I have a legitimate expectation, I don't use those things, a legitimate expectation to work until 67. Now, government is sending home people, some are statutory boards, who have that expectation to work to 67. They are pensionable, and you're not paying them the pensions. They're telling them if you are 60, you have to get your pension at 60. One young man came to see me. He was working from the time he was 18 at the government department. And his only error was that he worked 10 years. So they are giving him nothing. And they're saying to him that you will get your pension at 60, when you retire at 60. Or if you become medically unfit or sooner die. That is the only conditions, then the family will get it. So at 28 years old, he has to wait until, as currently misinterpreted in the public service, and currently being enforced by some hard-headed civil servants who have been giving the government law bad advice, that young man has to wait until he's 60. Now let's say he's entitled to a pension at 60. He will be entitled to, let's say, $30,000. 32 years down the road, he will still get that same amount of money, you know. You think that would be fair? That was never the intention. You were intended to get your thing. So these amendments that these are in reaction when you realize that you did something wrong and you're trying to fix it. You know? But you see, I don't fix my car. You know why? I don't know anything about it. I don't know about water, and there's that the fellow that want water, he's putting it for me. I do not know anything about them. What has happened here with the pensions is that people are fixing things that don't need fixing. And the Americans got a saying, if it ain't broke, don't fix it. But these things ain't broke. But government going ahead trying to fix them, and they're going to make matters worse. They're making matters worse in the case, but not in the case of the Water Authority, because the Water Authority was, prior to being the Water Authority, was the Waterworks Department. I think it was 1981 or 82, can't remember now. They became the Barbados Water Authority in 1982. But under the employees that were working at the Waterworks Department, they went over to the Barbados Water Authority with all their terms and conditions intact. The new set of employees came on, and people started to treat them as though, because the people who were responsible were the civil servants that know only civil service things. So they were treating them as though. So in 2006, the government recognized, you know something, Water Authority people it's supposed to be pensionable and should get unemployment benefits and stuff. So they amended the National Insurance Act, Section 12, to say that the Water Authority, the permanent employees of the Water Authority, are not supposed to contribute to the unemployment benefit or the sickness benefit or unemployment benefits here, no sir. So you're sending them home. They are no exempt from contributing or receiving any money for unemployment benefits from the government or from national insurance. But you send them home without recognizing that fact, you know. The government send them home. And then tell people, oh, get them what the people call it green paper, the termination certificate. Give them a termination certificate, and people bang off national insurance, and national insurance have to say, sorry, but you don't contribute. So government is trying to fix this. What government should have done is to fix it, but I don't know if Bert will allow them, Ernie or Bert will allow them, but they owe these people money. They send them home, you know. And they send them home in circumstances, in some instances, they didn't do the negotiations, get them the 6 weeks notice, all kind of stuff. So they're entitled to compensation for unfair dismissal. They owe people money. They make a mistake. They're trying to fix it. But no, trying to fix this, you put every statutory board under the contribute to the Servants Payment Fund. That doesn't make sense, sir. Section is 14. Section 14 is Servants Payment Fund. The Servants Payment Act, thank you. Says that if you are pensionable, and I'm paraphrasing again, you are not entitled to receive any money. And I got a chairman there who knows this thing good, so anytime she can put me up. You're not entitled to receive money from the National Payment Fund because you don't contribute. So the employers were not, the employers in the public service and at statutory boards, because they were pensionable, from time immemorial, because they were pensionable, they were never included under this. So they're entitled to get their pensions. So now you're entitled to get your pension, and now the government says, I'm going to put you on the Servants Payment Act. So you're going to give me a pension and some. Well, I'm not going to complain about that, because you're going to be getting two sets of compensation for one set of service. So that is what you're doing here. Well, if that's what the government wants to do, I am happy for all the workers, and I'm very grateful that the government seen the light and would compensate people twice, because you are entitled to your pension, and then you are going to be getting a servant's pay. That's why I'm saying that the government has been given very bad advice, because once before it was one or the other. Now, according to this piece of legislation, you're going to get both. I don't think that's what the government want to do. A broke government and want to do that. So, again, sir, I think it is best. I'm not even going to charge you a consultation fee. I'll sit down with you and go through it with you. I don't want the money. I just want it done right. But right now, the government has proposed legislation that is not going to fix a problem. It's just going to make the problem worse.
So you follow what you say?
And finally, also with the National Insurance Act, with the in Section 2 of this bill, the National Insurance and Social Security Amendment Act, they're saying they're going to delete Section 12C, 12.3C. And if memory serves me correctly, that is where you would be where you would, excuse me, sorry about that, sir. Where you would be required to contribute to your unemployment benefits and your sickness benefits or whatever. But I came into the service, and my employer has given me a contract. That contract, whether written or not, because the practice is, my contract is that I will get my full salary when I get sick. That's my contract. If you want to change that, you have to change that for people coming in. Like in 1975, when government wanted to change the pension arrangements, you were entitled to a pension from government service, and then you were also entitled to national insurance pension. So the government then passed legislation in 1975 that said that if you join the service after the 1st of September 1975, you will get your public pension from the Treasury reduced by the amount you get from national insurance. So essentially, you get one pension. You get basically the higher of the two. People who were working before that would get both pensions. As a matter of fact, it worked out good for them, because I have a friend, when he left his service as a senior accountant, and he was getting his pension from the Treasury, and then his national insurance pension, he was getting more than he was working for, you know, when he was, because that, the two provisions. So I don't have a difficulty when the government said, well, look, we can't be paying, I'm contributing to your pension, and also I'm contributing, and giving you a pension, I'm also contributing to it. So the government sought to say, well, look, I can't get both. So but they cut it off at a particular day. So now, if I am working and I have my terms and conditions intact, and you want to change conditions of service, you got to get my consent, or you have to make it for people coming in after. No. So if you change this now, you give people an sickness benefits, I am still entitled to my full salary. I'm entitled to my full salary from the government, and I'm also entitled to sickness benefit for the people who come in before this legislation is passed. Is that what you want to do? But that is what I'm entitled to my full salary for a year. And if when you work for a year, when you're sick for a year, sorry, then by the end of that year, they should have sent you before the doctors to decide if you're going to be medically fit to work or not. If you are not going to be fit to continue after the year, you should have been boarded, medically boarded. People just call it boarded in blank. So when a civil servant, he can be boarded, he knows he's going before the doctor, and the doctor will determine if he's fit to work. But you are entitled to your full salary up to that point, you know. What has been happening now, sir, for some people, is that the civil service machinery works slowly, especially at Personnel Administration Division. They have two gears, slow and stop. And they allow people sometimes to go on for 2 years, 2.5 years with pay. Not realizing that people sick, even though people send sick certificates, you know, because you have to send a sick certificate in order to get what they call an extension of sick leave on full pay in accordance with General Order 524.1. And then when you say, well, oh, okay, the fellow is no unfit to work, they tell you, but you know, so maybe pay you all that money, but then you will pay it back. So they seize your gratuity. It's unfair.
Senator,
So,
I was thinking that you are now into undisguised repetition.
No, sir. It's not undisguised. I'm talking about public service now. I've been into some another area of the being declared medically unfit. Right? So the problem here is, and a lot of people might feel so, but it is a real problem because several people now in the public service have their gratuity seized because Personnel Administration Division somehow forgot to send them before the medical board on time. That's what I'm talking about. That's not repetition. I'm not saying this for the first time. That's the area that we're having. We're having a lot of people in that department who, and I have no difficulty with people earning degrees and stuff, but you need experience also. I remember a couple of years ago, the University of West Indies invited me to a panel discussion, and they were talking about industrial relations. Oh, yeah, Sister Moore, Senator Moore was there. And they asked us what were the threats to industrial relations in Barbados. And I told them the biggest threat to industrial relations in Barbados is the program they have here at Kerrville. It teaches people nothing. Right? So so what has happened, what I said that a lot of these people went into that program.
Notwithstanding what you said.
Yes, sir. They went into that program, they got the degrees, and then they ended up in the public service, managing things that they had no idea about. And that is one of the biggest, that is why we are where we are now with all this mess. Because people who are advising the government went to that program, they got the degree, but they don't have the specific knowledge. I know of one man who the PAD used to send out to train people. He didn't have the degree.
You sure you're not now into anecdotal strain?
No, sir. I want to tell you why. He didn't have the degree, and they used to send him out to train people in the other departments. And then they changed the qualifications. Okay? And because he didn't have the degree, they say he can't be appointed to it. So the people that he trained got the job. But he didn't train them good enough. So they're giving government a lot of bad advice, but the people who can give the advice, because they don't have the degree, they take them out. And that is where we're suffering from now, sir. People who did not have the specific knowledge to give advice have given it, and we're now in a situation where government is paying have a lot more money than they think. And with those few words, sir, I know there were just a few, I'm much obliged to you, sir.
Thank you. Thank you.
Apparently, Mr. President.
You spoke for everyone.
Apparently. Cognitive debate.
Yes, it is.
Tony's going to say something. Thank you, Mr. President. I just want the record to reflect that this will be the first time that I can agree with much of what Senator Franklin has said. Much of what Senator Franklin has said, not all of what Senator Franklin has said, however.
There's a major qualification.
With that said, the amendments before us, we must recognize as aiming to achieve something very significant. What Senator Franklin has correctly said is that it was never the intention for government workers to find themselves in a position where they are forced to give up employment. It was always an anticipation that government workers would be in secure employment. In fact, I'm sure that many can identify with a position where parents, back in the time, you, Mr. President, perhaps, to encourage your children to find a job in the public sector, because a job in the public sector was a safe space, offering you the kind of security that you can raise your family on and so on. What has changed that situation? I would think that in many respects, it is the political element that kind of corrupted that system. I have to be very careful. Am I allowed to say that, Mr. President? Where you have a situation where there is space for so many people and no more, but for other reasons, there are additional people being brought into the system. In times of plenty, that can be sustained. In times of need, the system becomes compromised. So this is a situation that Barbados finds itself in, where there are more people that have been brought into the space than the space can accommodate. So then what has happened is that you're forced to consider factors that never had to feature before, and therefore that also conflicted with the whole notion of government employment or public sector employment being a safe space. This situation, or the amendments before us, many of them relate to the specific case confronting the workers of the Water Authority. As Senator Franklin said, these are workers who, like central government workers, never had to pay the NIS contribution at the same rate because they came out of the Barbados Water Works, and like many central government workers, they were employed with the understanding that they were coming into that safe space. But up comes the year 2018, not that it started there, but when there's the recognition that there are necessary changes that have to come. One of the things that, one of the results or outputs of the BERT program is that the Water Authority had to look at how it managed its operations. We went through a very tedious exercise where you try to trim, and where that trimming still has been contained to the extent that workers there are committed to ensuring the job security of others and willing to give up other conditions to ensure that even where it is felt that the space is overcrowded, that trimming does not have to go to the extent that some other organizations will be faced with. But I'm digressing a bit. Want to pull it back to say that in the case of the Water Authority, workers have received a severance. What the opposition senator is saying is true too as it relates to pensions. These are workers that are entitled to a pension. But if we have to look at the practicality of applying a pension, if a pension is stored and a person at age 45 or 50 is faced with the reality that there is no longer employment for them within a certain space, a stored pension means that you don't have access until you reach the pensionable age of 65. So the situation which we find ourselves in is a situation where, yes, you recognize that it was never intended that public sector workers should have to face unemployment. But given that the situation has presented itself, can we afford not to honor a certain expectation that if I am put on the bride line, that I won't have some cover for a 6-month period like other workers to hold me over until I can find something else to do? We can argue, and believe me when I say that the scenarios have played out in my mind, because some may know that in another place I'm a workers' representative. And it's played out in my mind that people who have not contributed into a system may become beneficiaries of that system. And that may be where the conflict comes for many in this room and for many who are following the debate. But should people who, due to no fault of theirs, who haven't been confronted with a scenario where they are now unemployed, be expected to wait another 15 years, 20 years in a situation where life is difficult in many respects, particularly in financial terms? Should they be expected to wait until that pension? So this now is the situation that we are presented with. Consequential, to fix that problem, it leads to a number of consequential amendments to the National Insurance Act, the Severance Payment Act. The caution or my reservation would be that these things are coming to us at short notice for us to consider, and while they appear to be reasonable, we would want to be a little cautious in ensuring that while we are trying to fix a problem, we are not creating a problem elsewhere. But where there is the situation that it is as it seems, and these amendments, simply as they're put, can address the problem of people who are thrown into unemployment, who upon receiving employment would not have anticipated that they would ever be confronted with this situation. And if it is even as Senator Franklin puts it, that they end up with unemployment, no, and severance, because it's severance and severance type payments, the actual severance payment and unemployment, which is consequential upon severance. And if it is that they receive that, and then at age 65, they also receive a pension, but going forward, we fix it, I have no objection with that. The only caution, as I said, and this is where the legal minds, I am not a legal mind, but I hope that there has been sufficient thought to ensure that we don't now compromise other people who are not those who are directly impacted, the 50 or so. And with that said, the question that I would want to raise relates to the amendment to the severance and employment and unemployment contributions. But this is the bill. I'm referring to Cap 355A, where the Severance Payment Act, where it is being proposed that effective the 1st of January 2019, that severance contributions will now have to be paid. Now, my statement of concern or register of concern is not to say that I believe that people going forward shouldn't have to make contributions into the Severance Payment Act for all the reasons that we mentioned before. But the concern comes that today being the 19th, and for people who previously have not been paying the contribution, and from the 1st of January, which would be in 13 days, they now have to pay this on top of a number of other impositions. My concern for workers would be for their own personal financial planning and the short space of time that they have between the passage of this amendment and the application to put plans in place, and that concern must be registered. Of course, I understand why from the employer's contribution side, it is not anticipated that employers would have to make the payments until when? The 1st of January 2021? That's what the amendments propose. Because somewhere along the line, and forgive me if I'm misquoting, but I'm seeing all of these things, a lot of these pieces of amendments, I'm being told within the last hour, but yeah, but we're seeing that employers, notwithstanding subsection 2, no contributions are payable under this act, that is 355A, to the severance fund for the period commencing on the 1st day of January 2019 and ending on the 31st day of December 2020. And this section 25, I'm sure Senator Franklin will correct me, but section 25 I think relates to employers' contributions. And so are we saying that the employers wouldn't have to contribute before 31st of December 2020, which will be in effect before 1st of January 2021, but that the workers will have to contribute from the 1st of January 2019? Because it would seem then that built in to this would be a proposal that will provide some cushioning of 2 years for employers, but no similar cushioning for workers. And that is where I would have concern, Mr. President. I would think that for consistency, we should align it. And if, like the senator to my immediate right, we are complaining, don't put that on employers. I would argue, therefore, in principle, we agree that going forward, the system has to be corrected all around. But don't put that on workers in the next 2 weeks. Defer it similarly for another 2 years. And that would be my contribution. I'm obliged, Mr. President.
Just Senator Mayor, sorry, was distracted temporarily.
Mr. President, I couldn't help but notice that there are probably about 10 glasses of water sitting on top of this desk here, and everyone seems to want to have some of this important thing. And someone thinks it might be vodka, but yes. So, Mr. President, all of us in here are about 65% water, and it is the most precious resource that we have in this country. No one is drinking oil. And there are things happening in this country that relate to water, Mr. President, that we have to speak about in this honorable chamber. Now, some years ago, we had a persistent drought. And areas of the country had almost no water at times had no water. And it coincided with the installation of, I think, I'll call it universal metering. We install smart meters that I believe provides
Mr. President,
tremendous...
on point of order, draw your attention to Standing Order 35. Scope of the debate. Debate upon any motion, bill, or amendment shall be relevant to such motion, bill, or amendment.
I will not raise. I will stop.
I'm not really sure what the Honourable Senator is getting at.
Enough time to show his relevance.
Just say he opens up talking about water on the table and so on. I look forward to hearing his contribution on severance and unemployment. Thank you.
Mr. President, in case we have not noticed, the matter that's being discussed is directly connected to the Barbados Water Authority and the severance of its workers. And it's no secret.
I think the senators, in effect, say demonstrate that connection.
So,
The matter before us. That was meant to stop you in the traffic.
we have to protect the vulnerable people in the country, Mr. President. Not only in terms of what they're entitled to when they're severed, but the ability to live and exist. And government, several years ago, opted to install backup supplies in villages that were affected by severe water outages. And in recent times, there have been disturbances of this water supply. And while it may seem at this late hour that I'm speaking about something that some persons might consider irrelevant, I think it's important that in this honorable chamber, we should not finish the year's session without speaking to how disheartened we should be when this water supply of the poor, less fortunate people who don't have their own water tanks has been withdrawn. And I want to thank all those persons who responded by doing generous donations, Mr. President. And I would like to hope that government pays some serious attention to making sure that the ownership of our water supply, whether it's desalinated water, water from the aquifer, that is protected, and that people should never be deprived of their water supply by individuals. Mr. President, I'm obliged to you.
Thank you, Mr. President. I want to thank all honourable members who have spoken for their contributions, especially my friend, the Leader of the Opposition, who displayed to us his knowledge at times a bit erroneous, but his overall knowledge, I'm only listening to the senator, based on what Senator Moore said. I'm merely quoting that. However, it was remarkable. It's very good to listen to, and I get the impression that he certainly understands for once what the government is trying to achieve. I certainly am pleased that it seems clear that he is in support of the bills that are before us this afternoon. I also want to commend Senator Moore in her circumstances in terms of contribution, and I promised her that I was here trying to look up to see in terms of a clarification regarding the amendment at Section 25, and I plan to look at it. And of course to thank Senator Maynard for his intervention. Of course it is important, especially as we approach Christmas. We would expect all Barbadians will have access to water. With this in mind and recognizing the season, I'm going to be extremely brief and beg that this bill be now read a second time.
The question is that the bill under consideration be now read a second time. All honourable members in favor, please say aye. Aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that Your Honour don't now leave the chair and the Senate goes into committee for further consideration of this bill.
The question is that I do now leave the chair, that the Senate go into committee of the whole Senate for the further consideration of this bill in committee. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it. We are now in committee.
Senate is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
Question is that Clause 1 stand part. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Which one are we looking at?
Clause 2.
Which are we looking at?
21.
This
21. The validation.
Huh?
The validation. No, I mean the actual bill. You have it. You will need it. Occupational training. Several contributions. The other one is the one of those that's already official.
So there is it clear?
It's there.
Oh. VRX 21.
Service on unemployment
Yes,
validation.
thank you.
And it just has 3 clauses.
Clause 2.
Mr. Chairman, I beg to move the Clause 2 stand part.
The question is that Clause 2 stand part. Honourable senators in favour, please say aye.
Can I say something
Those
at
against,
this point?
please say no.
Can I?
Yes.
Thank you. Mr. Deputy President, is just with Clause 2, I noticed that the date, the ST is bottom instead of top? The first. Is that at the bottom? It should be at the top.
Oh, yeah.
Clause
1st January
Third line,
2018, third line.
Oh.
It should be ST at the top. As a matter of fact, if the objects and reasons are going to be a part of this legislation, that needs to be changed on that page as well, Mr. Deputy President. That would be at the front, third line,
Yeah.
and throughout the, In relation to this section, clause 2, sorry.
And the bill. Under the bill, the entitled, it says the same thing. On it?
The very beginning of the bill. At the
Three
very beginning.
places, yeah.
Pardon me, sir?
At the beginning.
Yes, at the beginning on line 1, let's beg your pardon, line 3. And then for clause 2,
Third
clause third line at the end,
And
the
then
ST.
clause 3, circle line.
Same thing, but we haven't gone to clause 3, so I'm not going to be previous. Much obliged,
Yes.
Deputy President.
There's a typo.
That be treated as a typing problem.
You got the ST, should get it.
Mr. Deputy President, the same thing applies for the first. It would be the second line of clause 3. If you're bringing it quick, you could at least try not to make these kind of errors. Mr. Deputy President.
Point taken.
Mr. Chairman, I beg to move that clause 3 as amended stand part.
That's not an amendment. That's not an amendment. That's not an amendment. The question is that clause 3 stand part. Honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do not report to His Honour the President the passing of one bill in committee.
The question is that I do not report to His Honour the President the passing of one bill in committee. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that this bill be now read a third time.
Question is that this bill be now read a third time. All honourable members in favour, please say aye. Those against, please say no. You think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Severance and Unemployment Validation Bill Act 2018, sir.
Question is that this bill do now pass and be so cited. All honourable members in favour, please say aye. Those against, please say no. This bill is now passed. The ayes have it.
Order number 22, naming the Honourable Leader of the Senate to move the second reading of the Occupational Training Amendment Bill 2018.
Mr. President, I beg to move that this bill be now read a second time.
Question is that the bill under consideration be now read a second time. All honourable members in favour, please say aye. Those against, please say no. You think the ayes have it.
Mr. President, I beg to move that Your Honour do not leave the chair and the Senate resolve itself into committee for further consideration of the bill.
Question is that I do not leave the chair and the Senate resolve itself into a committee of the whole Senate for detailed consideration of this bill. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it. Over to you, Kathy.
Senate is now in committee.
Clause 1,
Mr. Chairman, I beg to move that clause 1 stand part.
Question is that clause 1 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2,
Mr. Chairman, I beg to move that clause 2 stand part.
The question is that clause 2 stand part.
Mr. Deputy President, with your leave, please, I'd like to draw the Senate's attention to the following proposed changes. Line 4, well, is that 4? First day, ST is at the bottom. 31st day of December, line 3. Is that line 3, Mr. Senator Walker? That would be considered 3?
I cannot see too good.
Yeah.
We're talking from, so clause 2, 31st,
Yes.
and then line 1, 2, 3, 4,
31st of
5,
July?
6. 31st of December.
31st day.
We have the first day of January. The first needs to be changed. The 31st day of December needs to be changed.
And the final.
of these, there should be a space between of and January on line 3. Line 7, which would be subclause B. First, again, day of January. And then 31st day of December. The 31st needs to be changed as well.
Yes.
You know, Mr. President, it concerns me with this level, you know.
But it appears to me as though the electronic, whatever you are typing with, that is where that first comes, and that is how it is written. I don't think a typist would have made the same mistake so many times. I think it is where it comes.
My issue, I'm not suggesting that, I'm not disagreeing with you. I'm just saying that the fact is that there is a mistake. There are mistakes. That always makes me nervous, Mr. Deputy President, because at least you can see this right away. What else is wrong that you cannot see right away? I mean, at the end of the day, we would have looked at 24 bills in one sitting. That, no matter how brilliant the Senate is collectively, is not reasonable. 22, 24, it is more than what is reasonable, Mr. Deputy President, considering that at least the last 4, 5, 6, 7, 8, or 9 of them we got during this sitting. It is of concern to me. It continues to be of concern. It is not reasonable, notwithstanding the urgency of everything that there is. Because what I don't understand is, if we had a deadline of the 31st, those bills that were available, why did we get them so we could have been doing them in pieces? Do 4 here, 3 here, 2 here, I don't know. But 24, 22 in one shot? That is not good. But the
point which I was making, Senator Tate, is that I don't think this first is a matter of the individual who was doing the typing. Yeah, it is, because this is where it is on, maybe on the computer or on printer or something.
Mr. Deputy President, I just want to intervene very briefly. We covered this ground in some detail this morning, and I really would not want to revisit it. The reasons for these bills being presented were explained in very great detail, and I would not want at this hour of the evening to repeat that process again. That being said, Mr. President, I am following online on the document, and I have no errors that are being reported in the printed version in my text. And this is a simple typographical error, Mr. President, that I don't think we need to make much ado over. We just have to have it corrected.
It concerns me that my insistence that legislation be done properly is considered much ado. I make no apologies for wanting the legislation to be drafted properly. And my issue is that how it's been presented to me, it has not been done properly. And no matter how many times the government would prefer me not to say it, it is not reasonable, the amount of bills we had today. It is not reasonable for these, because as minor as they are supposed to be, they are still errors. They should not be coming. And it does not take away from the fact that it's too much, too many times. Why could we not get them as 24 were not ready all at the same time? So come and bring them so that we can deal with them properly. That is my issue. And I make no apologies for talking about it. And if I sit here and don't talk about the ST being low instead of high, then if it's printed like this, I am culpable. So I make no apologies for raising it. And I'm disinterested in whoever has a problem with me raising it, Mr. Deputy President, typographical or not. Legislation, if we sit here and say, no objection, it will stand par, it means it goes as is. That can't happen if there's a mistake, however quote-unquote minor it is. Obliged to you, sir.
Mr. Chairman, I beg to move that clause to stand par.
The question is that clause is 2 or 3? Clause 3 stand par? Clause 2 stand par. Honourable members in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Mr. Chairman, I beg to move. Now, you know the report is honour the President the passing of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Disinterested. Will come to me about mistakes, fix them.
The chairman has reported the passage of the bill under consideration in committee.
Mr. President, I beg to move that this bill be now read a third time.
The question is that the bill under consideration be now read a third time. All honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Occupational Training Amendment Act 2018.
The question is that the bill under consideration do now pass and be so cited. All honourable members in favour, please say aye. Those against, please say no. The
Order
bill
number
is passed
23.
and will hereafter be so cited.
In the name of the Honourable Leader of the Senate, to move the second reading of the Severance Payments Amendment Bill 2018.
Mr. President, I beg to move that this bill be now read a second time.
Question is that this bill be now read a second time. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it.
Mr. President, I beg to move that Your Honor do not leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that I do now leave the chair and the Senate resolve itself into committee for the further consideration of this bill. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it. Over to you, Gabby.
This is the one we're doing now. That's the same.
The Senate is now in committee.
Clause 1.
Mr. Chairman, members would see in terms of clauses 1, 2, clause. I better move this clause 1 stand.
The question is that clause 1 stand apart. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, and clause 2, honourable members would see that the same problem you're getting in terms of the 1st of January with the STs at the bottom. With that being noted and to be corrected, I beg to move that clause 2 stand apart.
The question is, yes. Senator Moore?
Mr. Deputy President, as it relates to Clause 2, where the Act shall apply to persons employed with effect by statutory boards with effect from 1st of January 2019. Just want to take this opportunity to register the concern again that there needs to be greater balance. We have it applying to persons employed by statutory boards from 2019, but similar application not from employers of persons to statutory boards from 2021. So we really would want, if we're accepting this, that we align all to 1st of January 2019 or all to 1st of January 2021.
Which is the same point that you had made.
Yeah. Hold the order?
No.
We aligned it to either the 1st of January.
Either the 1st of January 2019 or the 1st of January 2021 for both.
Yeah. Point taken. Yes, Senator Franklin.
Sir, my colleague just pointed out to me here that it says the 1st of January, but this title is the first day of drug legislation, so if we can just fix that. But that's not what I raised initially to speak on. I just want to clarify. Where it says this act applies to persons employed by statutory boards with effect from the 1st of January 2019, if it means all statutory boards. Why I ask this is because if you look at the Statutory Boards Pensions Act, every statutory board is not mentioned in this act. the rationale behind the Statutory Boards Pensions Act is that the statutory boards that
Some have a pension.
make money will make their own pension arrangements, all right? As opposed to statutory boards like the National Assistance Board and Child Care Board that don't make money, they would come. So are you referring to the statutory boards under the Statutory Pensions Act, or are you referring to all statutory boards? Because this is important, because the Statutory Boards Pensions Act, well, people are taken care of already. Then we had a situation with the Water Authority, which was not under the Statutory Boards Pensions Act. As a result, they will not be getting severance pay. So what we want to do is to identify the particular boards. Like, for instance, CBC is not under the Statutory Boards Pensions Act. They have their own arrangement. Right? So I think we better get it clarified. Or not, what will happen, you will have statutory boards that are covered under their own arrangements, and then also getting things. So I think we need this to be clarified before we, if we are saying statutory boards and under the Statutory Boards Pensions Act. So if you look, the schedule, I think it is the second schedule to the Statutory Boards Pensions Act, which covers the number of statutory boards, the specific statutory boards under that are covered, that we are seeking, that we should not be covering here, right? And because you're going to be giving them, as I said earlier, 2 sets of compensation for things. So this was intended to fix the Water Authority, but rather than fix the Water Authority, I think you're causing a problem with the other, or not only the other, but with the government finances. I know the thing. Got the servants. If you tell the servants, you don't tell the pensions. But right. So it should be the board that the statutory boards that are mentioned in the second schedule to the Statutory Boards Pensions Act should not be here.
But you know, there's some that are not NMC, the Training College, Barbados Water Authority. These are the ones that you speak that not.
But no, the National Housing Corporation, under the Housing Act, I think it's Section 20, they have a special provision, a transitional provision that make them pensionable under the Pensions Act for civil servants. They're probably one of the few, probably the only statutory board that is pensionable under the Pensions Act for central government. Right? So NHC is not here because it's taken care of in the Housing Act section. I think it's Section 20, but we can always double check that.
Okay, thank you. Section 2. Mr. Chairman, I've taken note of the 2 matters raised, and I would certainly endeavor to pass on the need for clarification in terms of this. I beg to move that Clause 2 stand part.
Question is that Clause 2 stand part. Honourable Senators in favour, please say aye. Aye. Those against, please say no. We think the ayes have it.
Mr. Chairman, I beg to move the Clause 3 stand part.
The question is that Clause 3 stand part. Honourable Senators in favour, please
Mr.
say aye.
Deputy President, with your leave, please, may I draw your attention to line 3 of Clause 3. Apart from the ST in 1st and 31st needing to be addressed, if you're going to be consistent, there ought to be a comma by the word January.
Because no, they've been doing it all along.
Did you follow me, Mr.?
Yes, 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 yes.
The 2 dates and then the comma by January?
Yes, yes.
Much obliged, sir.
Mr. Chairman, typo is noted. I beg to move that Clause 3 stand part.
The question is that Clause 3 stand part. Honourable Senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you know the report to His Honour the President, the passing of one.
It's really good one.
The question is that I do now report to His Honor the President the passing of one bill in committee. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it. This is yours or mine?
This is mine. This must be issue. I made a change in the combination.
Okay.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that the bill be now read a third time.
The question is that the bill under consideration be now read a third time. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it.
Mr. President, I beg to now move that the bill do now pass and be cited as the Severance Payments Amendment Act 2018.
The question is that the bill under consideration do now pass and be so cited. All honourable members in favour, please say aye. Those against, please say no. The bill is now being passed and will hereafter be so cited.
Order number 24, name of the Honourable Leader of the Senate to move the second reading of the National Insurance and Social Security Amendment Bill 2018.
Mr. President, I beg that this bill be now read a second time.
The question is that the bill now under consideration be now read the second time. All honourable members in favour, please say aye. Those against, please say no. We think the ayes.
Mr. President, I beg to move that Your Honor do now leave the chair and the House, the Senate resolve itself into committee for further consideration.
Now leave the chair. The Senate resolve itself into a committee of the whole for further consideration of the bill in detail. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it.
The Senate is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 3.
Mr. Chairman, I beg to move that Clause 3 stand part.
Mr. Chairman, if you'll leave Clause 3, if I can draw your attention to the last line. For consistency, it would be from the first day of January 2019. We need to insert the words the and day of, sir.
This is the right one, huh?
Mr. Chairman, typo is noted. I beg to move that Clause 3 stand part.
Question is that Clause 3 stand part. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Next one. Report.
Mr. Chairman, I beg to move that you do not report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the Speaker, the President, the passing of one bill in committee. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that the bill be now read a third time.
Question is that the bill under consideration be now read a third time. All honourable members in favour, please say aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the National Insurance and Social Security Amendment Act 2018.
The question is that the bill under consideration be now pass and be so cited. All honourable members in favour, please say aye. Against, please say no. We think the ayes have it.
Mr. President, I beg that this sitting be suspended for 10 minutes to resume at 7:05.
Question is that we now suspend the sitting for another 10 minutes until 5 minutes after 7. All honourable members in favour of the 10-minute suspension, please say aye. Those against, please say no. We've now been in suspension for 10 minutes.
Legislation now coming.
We are now back in session. I hope we've all benefited from the short break. Where we know. New drafts, but at least one of them should be here every time because some people, grammatical and other errors could be corrected right here.
Sir, order number 16. In the name of the Honourable Leader of the Senate, assigned to the Honourable Minister of Information, Broadcasting and Public Affairs.
Senator Moore.
Yes, good evening, Mr. President. Before we commence and proceed, I'd like to, with your leave, do a cognate debate on 16, 17, and 18.
The question is that the items listed as 16, 17, and 18 on the order paper be debated together. The language of the mover of the resolution is a cognate and treated as a cognate debate. Honourable members in favour, please say aye. Aye. Those against, please say no. You think the ayes have it, and you may proceed to treat it as a cognate debate.
Mr. President, I rise to speak on the Immigration Act, Cap 190, and the Customs Act, Cap 66 of the laws of Barbados.
Please proceed.
As a cognate debate. I need to remind all present that, these are different times, and as a result, oftentimes we have to make changes to the way in which we do things. And one of these certainly is the way in which people enter and exit your territories. And so as a result, there's a need to enhance both domestic, regional, and international security. And that's one of the reasons for the amendments to these particular bills. Under our commitments to our CARICOM obligations, we would know that currently we use certain entities in order to assess and determine who enters and who exits our territories. And we use the CARICOM Implementation Agency for Crime and Security, known as IMPACTS, as well as the Joint Regional Communications Center, the JRCC. And they both receive advanced passenger information from vessels entering and departing from our territory. And the information is received so we're able to screen individuals and also match them back against watch lists to ensure that we know who's entering and who's exiting, and in order to maintain the security that's needed for our shores and our protection. This is done both for private aircraft and commercial aircraft, as well as all ships and vessels. At one time, as you know, some ships or some vessels, those under 100 tons, would not necessarily be screened. So oftentimes, people coming on smaller vessels would come into our waters, and not everyone on it may not necessarily have advanced passenger information given to us. So clearly, that is no longer what would be desired. So obviously, what we would want to see is a level of consistency as to how we treat to any and everyone entering our shores. So in order to achieve this, we also then have to look at the length of time that's given for people both when they're entering and exiting in terms of the information that's provided. And one of the changes, as you will see, is that we're moving from 15 minutes to 40 minutes for aircraft, which gives better time in order for us to be able to determine who the individuals are. Once someone is going from any of the member states or the CARICOM countries, sometimes the travel time is as little as 25 or 30 minutes. So obviously 15 minutes would not be adequate. So as a result, you're looking for a longer lead time in order to ensure that the information is received so it may be acted on. What you don't want is for people to enter and have gone through immigration and customs and not had enough time in order to verify and to see who the persons are and to check the information that's been provided. Now, you already know that with ships within the domestic waters, it's within our space, domestic space, it's an hour. And those that come from outside our domestic space, it's 24 hours, which will then give enough time for the checks and balances to be done. Now, Impacts will also share all the passenger information with other agencies like Interpol and other agencies that verify and ascertain whether a person is on a watch list, whether a person is fit to be able to enter your country. We also are looking to ensure that we get the information on the passenger name record known as the PNR, which is all the data that's captured in someone's passport at the time that they make the reservation. Whatever data is provided would then be in this PNR, which then also helps for better certification, for better due diligence to be done. And so we would obviously want that to be streamlined and to come in line with what many of our other Caribbean brothers and sisters do. In other words, we want to make sure that amongst the member states, there's some level of cohesiveness. So, it just facilitates much easier travel for everyone and obviously much better security. In addition, there's the Advanced Passenger Information System, APIS, which has been around for a while. It has been around since 2007 during World Cup, when it first came about, and that has continued to be used. And APIS also gives all the identification details and all of the travel information from your passport for people, your travel documents, for passengers traveling both regionally and extra-regionally. Now, this legislation will help to standardize a lot of what we are doing, certainly within the immigration framework. Suffice enough to say that with the advent of many changes to our society, where we now have all types of entities being established in Barbados, we have from universities as opposed to just Cave Hill, there are many other learning institutions now coming to our island. There are all these offshore universities. We also have instances of health tourism, which is also something that's also been on the as well. Anyone the water? Yes. So also health tourism, which will then also bring other people to our shores. And then, of course, all the day-to-day travel that we get within our tourism product, within our business environment. There are many, many people that come to our shores yearly. And certainly we would want to ensure that everything is done that is reasonable to ensure that people's travel is as seamless as possible. One of the worst things to have is to have traveled for a long time and then you're delayed because the information that is needed has not been provided. Once these entities are used and used in a constructive and cohesive manner, it then allows for your travel to be a lot less complicated. It becomes seamless. And that's what we would like for all the visitors coming to Barbados. For them to come here, have a pleasurable experience when they arrive, simply because the information is given ahead of time. So we know what to do and what not to do long before they set foot on the shores of Barbados. And concurrently for us, when we travel as well, because as you know, many Barbadians travel frequently all over the world, not just within the Caribbean environment. So, Mr. President, we are seeking, obviously, then to amend these particular acts in order to provide for a level of cohesiveness, a level of transparency, a level of safety, and certainly a level of cooperation amongst our member states and here in order to ensure that there's the ease of movement and ease of travel for all the people within that are coming to our shores. And with this, in addition, you will see that within the Immigration Act itself, there are some changes that we're also making in order to facilitate and make it easier for some persons that would previously have not been that may have been prohibited from entering Barbados. And these adjustments need to be done because certainly we would want to ensure that people who want to come to Barbados, especially with medical tourism, are able to come. If you would see in the original act that there were some persons that would have been prohibited, and with these particular amendments, that will all change, where those people could come here and seek medical assistance and not have to worry about having an issue when they arrive at a point of entry. Now, in terms of the Customs Act, you will see that there are much of this is almost interchangeable, where the same aspects that are related to passengers and to there are just a couple slight changes to the there are some concomitant changes because certainly what pertains to passengers also pertains to cargo or to any item or items entering the country. And the same thing will also pertain for that as well. And if you look at the amendments to the Customs Act, you will see that that amendment is very similar to the amendment to the Immigration Act. And that is why, obviously, we're doing these bills together, because the same entities are the same ones that are used in the process. The same JRCC impacts are used in customs in much the same way which they're used for immigration. So as you look at the amendments, you'll see that they look very similar, but one obviously is for immigration, the other one is for customs. But certainly anything entering or exiting a country would have certain similarities, certainly in terms of security and in terms of ability to be able to ascertain what is entering and what is not entering. And this applies to both ships and aircraft as well for customs, not necessarily persons, but certainly cargo or items entering, as you will see in the amendments. Now, having said that, these amendments are certainly important ones because, as I said before, both when I discussed the immigration aspect and the movement of persons, the same thing applies for customs. We would like to certainly see customs the regime improved for speed. You oftentimes hear people saying, oh, you know, things take a long time, can't get this. Some people have good, some people don't have as good an experience in terms of length of time for things to be processed and to be done. These entities and these amendments will allow for that and will then speed up a process which can only redound to the benefit of business persons and individuals who themselves are engaged in a custom activity where the importation of items and goods, in much the same way that passengers in the immigration aspect of this would benefit. And with that, Mr. President, I beg to move that it be read a second time.
Question is, this bill under consideration. I recognize Senator Franklin.
Sir, I promise you it won't be too long. But I couldn't be in this house and not speak to an immigration matter, especially, sir, on the 2nd of January 1980, I was appointed an immigration officer. And so immigration...
There's a query here as to whether you were thereafter disappointed.
It's better to answer that.
Order.
Yeah,
order.
sir. So, as I said, on the 2nd of January, I was appointed immigration officer. And that started my career in the public service. And it made me wise to a lot of things. I remember when I got transferred from the airport for telling off somebody. I was transferred to Bridgetown, and my senior officer told me, "Don't be fear. We can put you in the registry. You'll learn everything here." And because I like to mind people's business, put me in the registry. I read everything about immigration. And as a result, I knew who were the good officers. I knew who were the ones on the take just by reading the files. And I subsequently got transferred from immigration because I refused. I reported a man for bribing me.
You were graded them, huh?
Yeah, he man offered me some money for doing something, and I reported him, and next thing I got transferred. So that was my. You know, I thought when you did the right thing, you know, you got rewarded. But I still trying to be rewarded doing the right thing, and I will consistently do the right thing. Never forget, I reported this gentleman who offered me money and car and all kinds of stuff. And when I refused it, he told me, "But you know, so and so, I just get so and so thing. He don't make any noise." You call names. Anyhow, sir, when I read this, you know, like the first, like the amendment to the schedule, you know, that amendment is just saying, it's saying the same thing that we said before, you know, just that it was more specific. Because it says if you were an imbecile, if you're an idiot, and it doesn't mean the conventional Barbados idiot. You know, you call it idiot in Barbados, it talks about a fellow, like the fellow who, you know, go and dribble and shaggy tongue and that kind of thing. That is what they're talking about. But yeah, but the act says they were allowed in if they didn't have to prove that they have to work or they work their charge on the government. So when you change it, you just change it back to the same thing it was, you know. But that said. So we weren't really excluding any person. So if you came with medical treatment and you could afford the medical treatment, don't care if whatever condition you're in, we'll take you. Well, the body cadavers. My concern also is how immigration functions now since I've left. I thought immigration, you know, let's put it this way. Immigration officers, when you stay there too long, you start becoming like xenophobic. And they think that everybody wants to come to Barbados and take over this country from people who live here. And so they treat people who come to this country, especially our Caribbean people, very badly. I'm very disappointed in, because I work with some of those people that are still there. Right? And if you come to Barbados as a national from one of the Caribbean countries, you know, you get more scrutiny. they treat you as though you are coming here to do something wrong. You're not a tourist, you know. Tourists is supposed to be people coming from America and Britain and all kind of stuff. But a CARICOM national coming to Barbados, they get additional scrutiny from immigration officers. My problem, sir, is...
They're entitled to 6 months automatic.
But, you know, that's the problem. They don't even want to give them that. But prior to that, when we had a discretion to give you 1 day or no days at all, officers would give a person coming from the United States, Canada, wherever, automatic 28 days. They give the people from CARICOM a week. And then they had to go down to the department and apply for an extension, and probably, in a lot of cases, they didn't get it. And when you go for this extension, sometimes the people seize you. Now, you haven't done anything wrong, you know. But your visa is expiring, and they seize you, take away your passport, tell you to go and get everything, and send you home because they just don't like you, because you happen to be a CARICOM person. My experience, since I left the immigration department, became a consultant to the, dealing with immigration matters. And I have seen where they treat, especially children, from children of CARICOM nationals. Let's say you come to Barbados as a visitor, and then you work your way through, and you became an immigrant. You applied for immigrant status, and you got it. But you had children. You know, the children are then also entitled to immigrant status too, you know. If you are a permanent resident or a citizen, you acquire any one of those status, you would then be entitled to have your children registered as immigrants. But this is not what immigration department has been doing for years. When those little children come to Barbados, they give them student visas.
2 or 3 days.
Pardon? Student visas.
Oh, sorry.
And when, and there's a sinister reason for doing so. When you have a student visa, the time spent in Barbados on a student visa does not count toward the time for you to qualify for immigrant status or permanent residence or anything else for that matter. So you would have, and I know one specific case where this gentleman, his father was a Barbadian by descent. So, you know, like they say, you know, the sins of the father falls on the 3rd and 4th generations and stuff, but citizenship only falls on the 1st generation. So if your father was a Barbadian, then you can become a Barbadian by descent. But your children then wouldn't get the same thing because it only stops at the 1st generation, you know, not like saints. So he came into Barbados, he acquired citizenship by descent, brought his children. One child in particular was 2 weeks old when she came to Barbados. And at age 20, immigration said to her, but you were on student visa all the time, so you haven't acquired any time in Barbados, so you got to leave. She spent 20 years less 2 weeks in Barbados, and they're saying that she does not qualify for immigrant status because she was on a student visa. Answer. I fought that case though, and the Immigration Review Committee saw my way, and they allowed the young lady to stay in Barbados. But sir, immediately thereafter, because, let me go back, the 1979 student regulations only applied to persons who come to Barbados, study, and go home, come back, go home for vacation and come back. And that is why their status was not counted for continuation for any other status. Like, remember in the 70s we had Venezuelans coming to study Spanish and stuff. So when they come for that term didn't count toward immigrant status, because if you were here for 5 years and stuff, then you could become an immigrant. But they did it, they tricked the little children or tricked the parents and said, well, okay, we're going to give them student visas and all the time. But student visas were never intended for persons who live permanently in Barbados. After that point was established, clearly, from that case, you know, the then minister was persuaded to change the regulations to disadvantage children from Guyana and St. Vincent and St. Lucia again. So the immigration, but their xenophobic behavior, they were trying to exclude those children. And when it was pointed out to them that they didn't have that right, the Prime Minister, the then Prime Minister, who was Minister responsible for immigration, was persuaded to change the regulations to go back to that atrocity. So I want you people to check that. The immigration student regulations, and realize that there was a horror put into law by the last administration that will clearly disadvantage people from our CARICOM neighbors who bring their children to Barbados. You have people come to Barbados and work for years and bring their children with them, and then the children at 18, they're telling them, you gotta go home. And people cry. Airport collapsed because the immigration sent them out. And the thing is, some of those children who came here as babies don't know anybody in the country of their birth because they came as babies, and immigration won't send them back. They have done it to too many people, some of whom I've represented, and thank God they were spared. But the people that didn't know about me, what happened to them? You know? Right? Another atrocity, sir, is that you would see the immigration department serving a deportation order on somebody and grabbing them up and pushing them to the airport and stuff. Do not allow that person to get hold of their lawyer or their mother or anybody else for that matter and ship them out to Barbados. You have the right to appeal under the Immigration Review Committee under Section 2A of the Immigration Act. That committee was established to give people the right to appeal if there was a deportation order made against them. The Immigration Department do not allow the people to access. They don't even tell them that they have that right. They push them on the airplane. They grab them and lock them up in some lockup wherever they keep them, and do not give people the benefit to actually appeal because they have the right to appeal, but they don't let them appeal. I see lawyers and some of your friends who, cursing you know, but they couldn't get their way because they didn't get contact with the people. Because immigration department feel that they must treat people badly. When you go to the department and you're non-national, that makes you a criminal. And you go in there and if you deport a fella, give him the right to appeal. He has that right. It's enshrined in the law. Why are the immigration officers, or seems to be the policy now, that they secret you from your relatives and friends until the minute you're going to put you on the plane, they push you out on the plane, and that's it. You got to fight to get back in from outside. You can't appeal because what they say is that once you appeal, the deportation order is stayed, so they don't allow you to appeal. They don't give you the chance to appeal, sir. Right?
Are those rights set out clearly?
Yes, sir. It's set out in the Immigration Act, that section.
No, I'm talking about written on the wall.
No. It's set out in the law, but they don't tell people that they're in the law. This is Section 2A that sets up the Immigration Appeals Committee, Immigration Review Committee, and then it tells you further on down in Section 2B and 2C or whatever that the conditions that you can access these rights. If you apply for immigrant status, you don't get it, you can appeal. They don't tell you. You have to know or you have to find out. And in instances, some people go to the immigration department, the forms are simple. You fill it out. And you don't need a lawyer. But if you don't have a lawyer to fight them, they put you on the airplane and kick you out. It is not fair what they are doing to people in this country. It is unfair. Some of these people, I started working with them and I don't recognize them now. because they've gotten so hard and so harsh, you know. I feel like everyone wants to Barbados and carry Barbados from me, you know. And let me declare my interest first. My wife is St. Lucian. I should have done that up front. But she has citizenship, so you don't have to worry. But so they're not going to put her anywhere but they're sending me. But so she drew her first breath in St. Lucia. But if you saw her, you wouldn't know that she wasn't born here. You can't tell. But as soon as they find out that you were born outside of Barbados and you look like them, you won't come and carry the husband or the boyfriend or the jobs or something, and they treat people very badly. I go through it too many times, too often. I know a lot of people don't want to speak to these things because it don't sound like Barbados that you want to have, but this is the Barbados that really happening here. Treat those people well. I go to St. Lucia almost every year now, Christmas, and I am treated like royalty. From the time I set foot in the airport, immigration officers are nice to me. You know, it's refreshing.
When are you leaving?
Saturday. You know, and then we have to reciprocate. The people who come here don't get the same reception. We are treated very well when we leave this country and go away.
I hear it.
No, I'm entitled to a St. Lucia passport, but somehow I could get one now because if you have a St. Lucia passport, you can still be a senator. We know you chair that amendment, so I can get my. But I'm entitled to one. But I don't have one at the time. Okay, but I'm entitled to citizenship of St. Lucia. But I don't want another passport other than a Barbados passport. I love this place. And I want none even if I don't care if Trump can give me none, and I won't go there anyhow. But I love Barbados and I'm going to stay here. So I don't want to pass up anywhere else. But when I go to some place, I want to be treated better than how we treat people that come to Barbados. You get too many complaints. You hear all the time how immigration officers rough up people when they come to this country. But I think only immigration officers, you know. I remember, and I'm not going to call any name, sir. I was contacted some time ago by a company who wanted to set up a medical facility in Barbados to treat people coming from Canada. They will have these surgeries and whatever up in Canada, and they will come to Barbados and we recuperate. And so when they were offered the opportunity to get for $250,000, you know, if you give it this, we saw everything. People said, "I'm going to that." The CEO got put out. But he came to Barbados 4 times before, no problems. And because he refused to pay $250,000 to a certain person who will remain nameless, that man, when he came to the airport on the 5th occasion, they stopped him at the airport and put him out. So the medical facility, as a matter of fact, he was coming down to Barbados at that time to pay for land to site their facility, $12 million that they were going to buy this land for in St. Lucie. They came down with the deposit to pay, and when they got to the airport, because they didn't have the deposit plus $250,000, they never set for them back. They didn't let them left the airport. Yeah, but out. Of course, that meant that I didn't get my commission. But that's another thing. Sir, so I think only the immigration officers, we had people who work senior to the immigration officers that give this country a bad name because we want a little something from the people coming from outside. You know? I do not want to go too far because it's always late. Yeah. And my St. Lucian wife is waiting for me at work. So I have to go and get her, but I have certain things to say. And I want to say them. The next thing and the last thing I want to talk about is the Shanique Myrie incident. Shanique Myrie, and she came to Barbados.
Even though it is so well known, you want to speak about it?
The circumstances, not the actual person. What happened? She came into Barbados, and apparently she was granted permission to stay in Barbados. And then an immigration officer was persuaded to cancel her visa and put her out. It is a visa. There is no immigration officer in Barbados that has that right. I remember when the officer that was training me, when we went to our training course to become immigration officers, he always would say, let me tell you something. Be careful how you put that stamp in somebody's passport, because once you put it in, you can't take it out. Only the minister responsible for immigration can take it out. So once that woman had the stamp in her passport, I see the immigration people come up with some nonsense, but one day canceling something without prejudice. They'll copy that from the United States, but the United States may got regulations to suit that. Immigration officers in Barbados have no such power. After an immigration officer grants somebody a visa to enter this country, they can't take it out. That person is free to enter Barbados and free to Barbados, but no, in her case, they cancel the visa, and as a result, you know what happened. I'm not getting into the details, I'm just getting the circumstances, how this thing happened.
Known, very much publicized.
Yeah, you know, I won't get into details. I just want to get into the mechanics, how it got there. It got there because an immigration officer exceeded his authority by removing, saying he removed a visa. Only the minister responsible for immigration can do so, and the minister was not that immigration officer. Sir, I hope that some of the immigration officers are listening to this. I hope that they will amend their ways, because, sir, I am troubled by the way they behave. You know, I know they're not going to, and I represent some of them, but fairness, you know, they give Barbados in some instances a bad name.
What can you tell us about the supervision? Because what you're saying, I hear almost every time I go across the region. What does it say about the supervision that is available to them? Or they're not supervised?
Sir, the problem is, when you become an immigration supervisor, you were in the system long. So you become more xenophobic than the people who did that. You know, that's the problem. You know, the people at the top are more xenophobic than anybody else. We had an immigration chief who didn't like anybody at all from outside of Barbados. Mind you, she had a Canadian passport, but she didn't like anybody from Barbados, from outside of Barbados, and treated them very badly. You know who we're talking about, Senator. You know, it hurt me to see how they treat people. Sir, look, I'm not going to bother myself too much about it, but I just want somebody to set them on the straight and narrow, you know. Finally, there's a good thing about having a face to walk to see somebody else. You know, you have these machines, and you put the passport in the machine, you have all the advanced information. But let me tell you something. When I was at the airport, guy come to me, I was signal customs. You know, in those days, you used to give you a card. You used to give you a card marked customs. Those cards had a code. That changed. So this flight coming, you say, blue special, white check. You know, so you get a blue card, you get a special check. So when you assess that officer, you see that person coming before you, you see how they react, you see how they're behaving, and you signal to customs, this fellow needs a special check. All the time I was there was only one fellow I gave a special check to that didn't merit it. I gave him a card that he could go freely. And he said, how come you get here a blue card and you don't give me the blue card? You want blue card? I give you one too. And they showed me down to his socks. Those few words, sir. I'm obliged to you. No, they're not. They haven't done. Well, Pedro was immigration officer too.
Grant? I recognize Senator Grant.
Thank you, Mr. President. The hour is late, and I know that we do not wish to be in the chamber very long. I believe, sir, that the amendments we have before us are very positive and very good amendments, and that they will contribute in a significant way to the overall experience of passengers utilizing the Grantley Adams International Airport. Mr. President, you will continually hear me make reference to experiences, because in today's world, it is very important, particularly for countries such as Barbados, where tourism is extremely important and provides significant foreign currency and provides significant employment, that we are able to positively respond to the requirements of our visitors. Sir, the Virtuoso Lux report, which is looking at what is expected in 2019, indicates, sir, that visitors for personalized travel are expecting greater experiences. And I'm very happy, sir, with these amendments that are being proposed, because as I indicated, I expect that they're going to contribute in a very positive way to the overall experience. Sir, I recently participated in a millennial forum. In fact, that forum took place last week, Saturday. And it involved 15 millennial travel agents out of the United States. And I took some notes, sir. I want to reflect on some of the comments that came from these travel agents. Sir, you know, as you get a little older, you have to wear these readers to help you better see what it is you have written. One travel agent, sir, indicated that the product had positively improved, great for families. He went to Bushy Park, found that it was very exciting. Another, sir, was impressed with the island, the number of people that they met. A third one spoke about how safe they felt in the destination, how very safe Barbados is, how very accessible, spoke to the many restaurants, spoke about how beautiful the beaches are. Another said that he felt very comfortable being part of the LBGT community. That's the terminology. And that he felt rather at home and safe. Another person said, sir, that... Wait, this? No, I am familiar. I must tell you, sir. I must tell you, sir, that I am not very familiar with that. So if I'm incorrect, sir, please correct me. Please, but sir, no, if I'm incorrect, please correct me. I must say I'm not very familiar. Another said, sir, that they were struck by the friendliness of the locals. It's open and it's super safe. Another, sir, talked about the different offerings that we have. Another saying, sir, that it is very safe, and talking about the food and the entertainment. Sir, I reference these comments from the 15 travel agents because I think it is important that we understand very clearly the brand elements, and that we also appreciate how those individuals that are actively involved every single day in promoting and selling Barbados as a destination see us. But sir, we have to ensure that we are able to protect our brand elements. And you would have heard in those comments reference made to how safe and secure Barbados is. And I'm happy, sir, that the amendments facilitate for ensuring that Barbados is even a safer place that persons can come to through the provisions that have been undertaken. But I don't think, sir, that it stops there. I'm very aware that at the Grantley Adams International Airport, they are facilitating new scanning equipment. Scanners, sir, for baggage and scanners for passengers. And all of that is to assist in facilitating easy movement of passengers from the time they get off the aircraft until they get into their vehicle and leave the Grantley Adams International Airport. Sir, the Minister of Tourism has had many consultations with officers at the Grantley Adams International Airport. The Prime Minister has convened many sessions with officers at the Grantley Adams International Airport. Customs, immigration, police. And the reason for that is to, yes, hear their concerns and to ensure that they have a clear understanding as to the direction in which government wants to go in. But also, at the same time, to ensure that we are properly facilitating passengers through the Grantley Adams International Airport. The expectation is, sir, that very shortly we will see the removal of immigration officers as you depart Barbados, as you go through the departures terminal. The expectation is that we've been given this commitment that immigration officers will be removed. The truth is that in many jurisdictions that already happens. But that again contributes in a very positive way to the overall experience that passengers are having. Sir, if you go to the Grantley Adams International Airport now, when you go by gate 14, you would see that there's some work being undertaken. And what is happening there at gate 14 is that in the past, in that particular area, air-sea passengers were facilitated. What is happening, sir, is that in the past, that the area might have been a bit hot. You had some fans, but now the work that is being undertaken is facilitating air-conditioned units and some expansion and making it more comfortable for the air-sea passengers and for any passengers that utilize that area. So I can tell you as well that at the Grantley Adams International Airport, you have a situation where additional customer service agents are being employed. And the reason for that, again, is to seek to ensure that you have persons there to properly accommodate the visitors. Now, sir, if you go to the Grantley Adams International Airport during this winter season, you will hear some lovely Bajan music, some good Bajan music. In fact, you will see some performers as well. You will get the opportunity to participate in some Bajan delicacies. I have to tell you, sir, that when we travel to promote Barbados, or when travel agents come here for us to tell them about Barbados, one of the products that the agents are always fascinated with is rum. And we are very happy, sir, to always tell the agents that Barbados is the place that invented rum. And the visitors, as well as the agents, enjoy that good liquid refreshment. So we are going to ensure, sir, that we continue to encourage them to engage in our Barbadian delicacies and our offerings as well. Of course, because we are very responsible as well. Mr. President, sir. In November, early part of November, I attended World Travel Market. And that trade show allowed us the opportunity to interact with quite a number of tour operators and airlines. Almost all of our partners, Mr. President, indicated that for them, Barbados is the #1 selling destination in this region. I want to repeat it, sir. That almost all of our partners indicated that Barbados is the #1 selling destination in the region. Therefore, we have to ensure that we maintain our position, because I've said it before, Mr. President, no one owes us anything. The competition in the tourism industry, sir, and the competition for Barbados is not a St. Lucia or a St. Kitts or an Antigua. Competition in the Maldives, the Seychelles, Mauritius. The competition is really global. And we have to ensure that we are constantly up in our game. We have to ensure that we are constantly able to offer our visitors more, particularly at a time when the cost of traveling to Barbados has increased. So I'm very happy, sir, with the amendments that we are making. But I want, sir, to tell us that we have to ensure we protect the important brand elements. And there are 2 brand elements I want to speak to today. And those two brand elements, sir, are, and I did say that it would be short. I believe, sir, if I look at my work, sir, I believe, sir, I was only speaking for 5 minutes. But I'm going to be quick. There are two brand elements I want to speak about. Those brand elements relate, sir, to cleanliness, and they relate to safety and security. As it relates to cleanliness, we do have to ensure that all of us recognize how very important it is to play our part. I would have seen, sir,
Go ahead.
Mr. President, I would have seen, yes, sir. I would have seen, sir, at the front of today's Nation newspaper, a photo and reference to the refuge situation in Barbados. I'm very happy, sir, to report that I know that the Sanitation Service Authority yesterday went to Bagatelle and dealt with that area. I'm very happy, sir, to report to you that I know that the Sanitation Service Authority has put a strategy in place for the cleaning of Barbados, particularly during this Christmas period. There was a schedule where there's going to be a cleanup for every parish with 10 of the 15 trucks that the Sanitation Service Authority has, and with another 5 trucks continually roving, so as to ensure that we properly facilitate the cleanup in Barbados. With respect to the issue of safety, we have to ensure, sir, that we properly deal with the issue of crime. There are some elements, sir, and it is certainly nothing like what happens in other jurisdictions. But we have to make sure that we do not allow the crime situation to escalate. I'm happy to report that certainly at the Barbados Hotel and Tourism Association, we've had some collaboration with the Royal Barbados Police Force. We've had collaboration with other entities as well to ensure that we keep the environment in a certain condition that it minimizes those who have a tendency to engage in criminal aspects. Of course, Mr. President, there's that nexus between immigration and customs. And the customs has informed, or would have informed previously, that the airport is not a significant revenue earner for them. The concern more relates to dealing with drugs or dealing with people bringing in prohibited items. It is good that the government is facilitating the amendments to the Custom Act, and it is good that the government is looking as well to introduce the new scanning equipment that I talked about, so that there will be a quicker movement of passengers through the Grantley Adams International Airport. Sir, I think it is important as well to recognize that in this environment, all tourism enterprises have to collaborate in order to make sure that we enhance that visitor experience. And Mr. Deputy President, I remember some time ago, a friend of mine, the market vendor, I believe, commented on statements made by the CEO of the BHDA as it related to ensuring that there was taxation and regulation for the sharing economy. That obviously, sir, has been introduced. And I want to make a call. I want to suggest that all tourism enterprises that we need to collaborate, and I want, therefore, to appeal to the sharing economy, the Airbnb Association, and all the others to allow us to be able to collaborate. Mr. Deputy President, I am not going to go much further. There's a lot more that can be said, but the reality is, and I'm sure that there will be other opportunities to speak to issues relating to tourism and what is happening in this very important industry. But, you know, sir, I'm going to end on this point. The success of the industry does not only depend on the amendments that are being facilitated in these bills. It does not only depend on the policy initiatives that are being put forward by the government. It does not only depend on the actions being undertaken by the tourism practitioners, whether at the BHDA or in the Ministry of Tourism or at the Barbados Tourism Market. It really depends on the actions of all Barbadians. There was a time when there was a very common phrase, tourism is our business, let's play our part. All of us, sir, have to recognize that it is important in this very critical and important industry that we play our part in order to ensure that we expand and improve this very important tourism industry. Sir, with those few words, I'm obliged to you.
Senator Boyce.
Recognize Senator Boyce.
Thank you, Mr. President. Fellow colleagues, night is with us, and we seem to be in it for the long haul. We have had a wonderful history lesson from our beloved Senator Franklin in relation to his days of yore, and a wonderful exposition of the Barbados tourism product by our also beloved Senator Grant. And I like how he was able to weave together the importance of tourism and the fact that we need to keep our visitors and, of course, ourselves safe. For my part, I rise on a somewhat personal note because aspects of security and CARICOM I hold very close. Now, a very brief CARICOM lesson, because other senators are much more versed than I am in this area, is that there are 4 pillars of CARICOM. First is foreign and community relations. Second is trade and economic integration. Third is functional cooperation. And the fourth is security. And what we're seeing in this legislation, and besides this being a debate in relation to the legislation that's before this Honourable House, is the government's implementation of the regional resources to aid in the security of the country. Now, Impacts manages CARICOM's actions agenda on crime and security at a ministerial and regional level. Locally, the JRCC, that's Joint Regional Command Center, which is located here in Barbados, does the legwork. And these persons do a tremendous job and have been doing a tremendous job in protecting our borders and ensuring that we can continue to live quite unaware of the sacrifices that they're making. And I wanted to draw it to the House's attention that this type of facilitation of intelligence should be commended and that we continue to aim to bring legislation which ensures its optimum utilization. Now, for my part, I believe that we need to go further in that CARICOM needs to strengthen the intelligence integration to all the territories. I also believe that funding for these resources should be maintained and developed akin to how we have successfully done so for the CCJ, much to the chagrin of Senator Franklin. But the aim is to have a body which is independent of governmental and or ministerial control in one day and have a CARICOM body which is so funded to ensure the continued independence, but would rely, of course, on government as well as private sector and NGO contributions with regard to ensuring its ongoing independence. In other words, currently, the powers of the protection are overseen by the ministers of government and their respective Caribbean counterparts. And we have been blessed with dutiful ministers. But let's take it further. Why not have a consideration of an independent body which is independent and separate from any governmental, well, you will have governmental supervision, of course, because no one has to be without checks and balances, but would not be in of itself subject to the whims of any particular government and or opposition, and to encourage the linkage between the Caribbean community as we go forth and seek to protect our borders. Finally, I just wish in closing to personally thank these silent sentinels who guard our walls. It is a thankless job. I think the majority of persons are unaware of it, and I would wish that we as a House commend them for the service that they provide to the nation and to the Caribbean region. I thank you, sir.
Thank you, Senator.
Thank you very much, Mr. President. I rise on this occasion also to be very brief and to speak on the amendments which are before this honorable chamber. Mr. President, Senator Moore has very ably outlined the contents of the amendments to the immigration bill and the categories of persons to which it attempts to treat. She has also outlined for our benefit the kind of information which is meant to be captured by the Advanced Passenger Information System as it relates to both persons through the immigration system and those in the cargo trade, those entering Barbados on cargo ships. The system globally that we are attempting to implement, the Advanced Passenger Information System, in some countries, Mr. President, is used to issue advisories, pre-clearance inspection, to advise on wait times at borders, that kind of information when the system functions optimally. And I'm looking forward to us being in a position where we are able to see that optimally in an expanded system here in Barbados. Equally, Mr. President, As it relates to the Customs Department, as amended in Cap 66, which we're now treating with, we're talking also about advanced passenger information. But I want to put this in context for us today, Mr. President. And I want to say that while we are making important strides, and I second the call being made by Senator Boyce as it relates to us going a step further, I also wish to commend the work of our regional agencies. I wish to commend our CARICOM partners for being able to ensure that there's this level of coordination at a regional level. But I want to speak specifically in this instance for a few moments, Mr. President, about the importance of us ensuring that we go further nationally as well in terms of our domestic space. There are moves afoot in many jurisdictions around the world to integrate immigration and customs entities in a way that allows for coordination effectively and the effective sharing of data and information on both persons and cargo. What we have seen in Barbados, Mr. President, has been a regrettable scenario where, while we are capturing passenger information, we have failed to move to the next step as it relates to our Customs Department to capture cargo information by implementing a single window system. Mr. President, if we are in a position to implement a single window system in Barbados, it considerably speaks to the question that was raised also by Senator Moe about our doing business efficiencies. It talks also about our ability to clear containers and cargo through the port in an efficient manner very quickly, but it also speaks to another matter which is currently occupying the attention of this House, the question of corruption and ensuring that there is collection of data in a single and a centralized manner. Mr. President, around the world, these systems have been implemented, and there's a study which I was able to find as I was preparing for this debate, which was prepared by the United Nations Council on Economic and Latin American, ECLAC, for Economic Commission for Latin America and Caribbean, and it spoke to the various economic commissions for the various regions. And it said the following, Mr. President: not all players in the government and or international community or trade community welcome the implementation of these single windows. Opposition to its establishment can come from within customs departments. And it spoke specifically to an instance in Madagascar where opposition to the reforms were widespread for several reasons. One, the private sector was resigned to the inefficiencies and corruption in customs departments and were reluctant to start paying any additional fees that the project would require. Additionally, the large customs department equally was also reluctant to change its ways. I'm saying here, Mr. President, that we have an opportunity to use the technology which is going to capture passenger information to go a step further, to look at using the technology equally to capture our cargo information on our transactions as it relates to cargo coming into Barbados. This is one of the things that Barbados must treat to as a matter of urgency in a 2018 Barbados, and certainly on the eve of a 2019. In 2013, we had around 700,000 passengers passing through Barbados, and last year we had about 818,000. Can you imagine capturing this kind of data in a centralized system that then is shared simultaneously all across a national infrastructure which is well coordinated so that we can treat with the matters of national security, national coordination, and also data capture. Mr. President, I think that these are important amendments that are being brought to our legislation. I think we still have a ways to go, and I'm confident that the government is going to take us along that journey, and I rise on this occasion to support the amendments and also to express my support for the continued journey along this path. Thank you, Mr. President. I'm obliged.
Mr. President, I rise to make just a small contribution to the debate. And I want to say that I have heard people commend the police. I've heard people commend teachers. I have heard people commend sanitation workers. And just a few moments ago, I heard people commending the regional agencies. And I'll be honest with you, I do not hear a lot of people commending our immigration officers. And I must say that I think that the immigration officers in Barbados do a tremendous job. I do not agree with Senator Franklin that they treat Caribbean nationals badly. And I do not want it to go forth from this chamber that this Senate has said or agrees with that statement that our immigration officers treat Caribbean nationals badly. I cannot accuse our immigration officers of xenophobic behavior. I know nothing about that and about them behaving that way. What I can say is that our immigration officers, one of the primary functions that they perform is that they stop Barbados from being overrun. And they try their best to regulate the length of the stay of those who come to Barbados. Regardless of how small a country you have, this is little Barbados. And regardless of how poor you may consider your country to be, there will always be persons who want to come here in a very unrestricted manner. I know of little Grand Turk in the Turks and Caicos Islands where it's all. And almost a place of insignificance. And would you believe that there would have been boatloads and boatloads of Haitians and people from the Dominican Republic trying to overrun little Grand Turk, trying to get into Grand Turk, a place that we may call insignificant. So regardless of what the country is in terms of resources or whatever, you have to control the people who come into your country. And our immigration officers have been doing this for our country, and they have been doing a tremendous job. And very often, you know, when people go to the Turks and Caicos or people come into Barbados from elsewhere, it is not because they're millionaires, you know. A lot of them are finding it hard in the country in which they reside. And they're coming here and they don't have buckets, loads of money. They don't have a lot of money. And they stay here for a few weeks perhaps. Then all the money is gone. What can you expect? What can you expect? They may do something illegally. They may steal. They may get into criminal activities. And if the immigration officer says up front, no, we can't, what is wrong? Why should you say that they're xenophobic? Why should you say that they treat CARICOM people badly? People are involved, Mr. President, in all types of fraudulent practices in order to trick immigration officers, you could almost say throughout the Caribbean. I played cricket, I played for school. I got 2 minutes. I played for school. I played for school, and school was a team.
There's a new president, man.
And the umpire, he gave me the day and I wasn't too pleased, that's the truth. And when we met afterwards, we had a discussion. He had come from Jamaica. And he related to us how he got to the Cayman Islands. That was in Cayman, how he got to the Cayman Islands. Because things in Jamaica were rough, and everybody was leaving. And they were living with money. And the rule was you couldn't leave Jamaica with a certain amount of money. Jamaica was saying that isn't fair to us. And he said, I decided that I would use my own method to get the money out. He said, I went to the airport.
I sent a message and I told immigration, I told them, a fella is going to pass through here with his arm bandaged up, plaster of Paris, and it's going to be thick. And he has all the money in this hand wrapped up, all the $100 bills and so on. When he got there, immigration, he had his hand plastered. Immigration officer said, "I got you." Cut the hand off, cut the plaster of Paris off. Not the hand, not the hand, not the hand, not the hand, not the hand. And we went through carefully, wrapping it, unwrapping it. Not a cent, not a dollar bill in the hand. And he said, "I'm going to sue you all. In fact, I'm coming back this evening on the 5 o'clock flight." And he went home. He said he put every single $100 bill he had in his hand. He wrapped it up again, and he come through customs, and he felt so okay, come through. And he went through, and he ended up in the Cayman Islands with his money. But I am saying that just to show you the lengths that people would go to trick immigration. Our immigration officers do good work. Do very, very good work. Now, people have argued, so one more minute. People have argued that there is delay going through that TSA system at the airport. They've said that it slows down travel and that you have to get to the airport 2 hours in advance. Then when you get there, you got to take off your shoes, you got to take off your belt. And I have to say that I don't mind it. To be quite honest, I do not mind it. I do not mind that. I think that the emphasis should not always be on speed in getting through there. I don't think we should run down the clock just to say, well, we went too fast today and so on. If that thing is to keep me safe, I feel good about it, no problem. No problem whatsoever. It might not be me. It might be the next fella. It might not be me. It might be the next fella. And I don't mind you spending time and going through and making a proper check. I don't mind that at all. The other thing is that, half minute. The other thing now is that I have an Indian client, and his complaint to me was that immigration takes too long to grant people immigrant status. And he told me to check and just make a little contact for him to see how his application was going. And the people told me, quite frankly, we have to be vigilant. The problem with his, there are lots of similar names. He says sometimes you get the first name and the last name. They would have had a list of about 10 people that carry the same name. 10 of them that carry the same name. You have to look at the photographs properly. They say sometimes the very documents do not correspond. That the passport might have one name spelled one way, and the birth certificate has another name spelled the same way. And that they have to go through those things, and they have to go through them properly and thoroughly. And therefore, it is not a matter of rushing this thing through, and so on. So I had to explain that to him. So it's not that the people at immigration are slow and they're bad and so on. That is not true. They have their work to do, and they do it properly. The call has been made on a number of occasions. I made it already, saying that we should have immigration officers at the airport who can speak at least 2 languages, English and French, or English and Spanish, or English and Mandarin. But something they should, and I do believe that you may get 2 of them, a few of them, who might be able to do it, might be able to correspond. But I think that by and large, I think we need some type of training course for them. I think there's a contact that we have also missed. A Chinese, he goes to immigration, whenever they have a Chinese person to interview, and he is supposed to work there, that he goes in there when they call him, and he would translate for them what the Chinese person is saying. I think that can be dangerous, though, because he can tell them what translation he wants to tell them when a particular Chinese person is there sitting down. You see? And I believe that we can use our people. We have an embassy in China, and I think we also have people who have come back from there and who speak Chinese and write Chinese very fluently. They speak very fluent Chinese now. And we can use those people, but we are not forward-looking. We have not used them. We have not used them at all. But I think it is time, too, that we stop saying people should be speaking the two languages. I think it's about time we start doing something about it and training them and setting a goal and saying, look, in the next 10 years, every single immigration officer must be speaking two languages. I'm obliged to you, Mrs.
Mr. President, I would like to thank all of my colleague senators that contributed to this debate on this ever so important bill. I too would like to say with regard to impacts and JRCC that they have been doing an extremely wonderful job in terms of the security of our country for quite some time. These agencies oftentimes go unnoticed because people may not even be aware that they exist, but I do concur with Senator Boyce that they should be commended for the outstanding work that they have been doing. Just to say, though, in reference to the assistance in regards to what's available for both impacts and APIS, the CARICOM Secretariat, if you can indulge me, Mr. President, I would just like to read from this document. The CARICOM Secretariat has garnered support in its efforts to expand CARICOM's Advanced Passenger Information System. The United States government and the Caribbean Basin Security Initiative, CBSI, has pledged $1 million in equipment to the JRCC. The funding would assist in enhancing the center's capacity and capability as it relates to the screening of passengers. There is a condition for the disbursement of the fund, and that is that the majority of the member states enact the harmonized APIS in order to receive this funding. Furthermore, under the, Mr. President, with your indulgence, under the 10th European Development Fund, resources are available to JRCC, to embark on initiatives geared towards expanding the APIS to specialized units and departments in the respective member states, which will enhance operational. So the member states do treat this situation in a serious manner, and they are being given some level of assistance. As you would imagine, this exercise can be quite costly. And just to wrap up, Mr. President, to say that this legislation, as I articulated earlier, will not just enhance the security of our country, but as was said by one of my colleagues, I'm not sure which one, but I did hear someone mention it. As I said earlier, it also will assist in the ease of movement of passengers, which is important. It gets away from those extremely long lines. I know my fellow senator who was a former immigration officer, I think he's also a trade unionist, a lawyer, arms expert and gun expert and defense force. And I know he's been in many professions, but certainly in terms of immigration, he's also expert in that area as well. But just to say that, times have changed a little bit from the many years ago when you would have been in immigration. And, you know, technology has advanced, people have advanced, and certainly I think Barbados as a country, we as a member of CARICOM will live up to our CARICOM obligations and the free movement of CARICOM nationals, and certainly we will ensure that people, when they come to our shores, as much as possible, are given the automatic 6 months that they are entitled to. And we have shown that. I think we are one of the first member states that have been expeditious in our treatment towards Haitians who have now been coming to our shores. And certainly Barbados, yes, it might be a small place, but at the same time, it probably is a little underpopulated. Certainly many of us here sitting in this chamber have worked in other Caribbean jurisdictions. I myself have worked in 8 Caribbean islands, and I feel that CARICOM nationals should be allowed to freely move around, because it could only be to the benefit of us as a region. We cannot be isolationists. We have to understand that we learn from each other. And I've always said, if Europe, with their history of all the wars, of all kinds of things, from religion to all sorts of things, race and all sorts of things, can come together, certainly the CARICOM, the Caribbean region, must understand that these islands, that's what we are, small little islands, must come together and must work together in some level of cooperation for us to be able to be a player on a much larger world stage. We cannot, as small countries, as isolationist countries, all of us in our own little space, expect that our little 166 square miles and not even 300,000 people, if we don't come together, or St. Kitts, with their roughly around 50,000 St. Kitts and Nevis, we need to come together, and I hope that we recognize that this piece of legislation is a step in the right direction for the facilitation of the ease of movement of individuals of our region. And just to wrap up and say that this, I hope everyone here will support this legislation, because it is extremely important for us to move forward as a country. And with that, I would like to beg that it be read a second time.
The question is that this bill under consideration be now read a second time. All honourable members in favour, please say aye. Aye. Those against, please say no. Think the ayes have it.
Mr. President, I beg to move that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the further consideration of this matter. All honourable members in favour, please say aye. Aye. Those against, please say no. Over to you, Gabby.
The Senate is now in committee.
Clause 1.
I beg that clause 1 stand part.
The question is that clause 1 stand part. Honourable senators in favour, please say aye.
Aye.
Those against, please say no. Methinks the ayes have it.
Clause 2.
The question is that clause. Yes, go ahead.
I beg to move that clause 2 stand part.
The question is that clause 2 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 3.
I beg to move that clause 3 stand part.
Mr. Chairman? No, I'm sorry, but Sir, it's very brief. Line from 3A, 1, 2, 3, 4, you should have a space between JRRC and with.
She says clause 3. You got to say clause 3. Senator, could you repeat that again?
Sure, Mr. Chairman, on line...
Clause 3.
Clause 3 from your, from 3A, there should be a space between JRRC and with. Where I am. You see it, sir? JRCC and with. Well, there's none in mine. So if it is there, just make the space. You have one in yours?
Yeah, with the space.
Not with mine. Thank you, sir.
Thank you. But there's a space there. Yeah. Question is that clause 3 stand part. Honourable members in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 4.
I beg to move that clause 4 stand part.
The question is that clause 4 stand part. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 5.
I beg to move that clause 5 stand part.
The question is that clause 5 stand part. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 6.
I beg to move that clause 6 stand part.
The question is that clause 6 stand part. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it. Report. You have the schedule?
No. Schedule is part of clause 6.
Report the passing.
Mr. Chairman, I beg to move that you do now report to His Honour the President for passing of the bill, one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. All honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move the bill be read a third time.
Question is that this bill under consideration be now read a third time. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Immigration Amendment Bill 20 Act 2018.
Question is that this bill do now pass and be so cited. All honourable members in favour, please say aye. Aye. Those against, please say no.
Order number 17.
Thereafter be so cited.
17.
Order number 17, sir, in the name of the Honourable Minister of Information, to move the second reading of the Customs Amendment Bill 2018.
I beg to move that it now be read a second time.
Question is that is the bill currently under consideration, we now read a second time. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it.
Mr. President, I beg to move that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill.
Question is that I do now leave the chair and the Senate resolve itself into a committee of the whole Senate for the consideration of this bill in detail. All honourable members in favour, please say aye.
Copy this one.
Those against, please say no. I think the ayes have it.
The Senate is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I'd like to move a amendment to Clause 2. Would like to delete on page 5, where you see treaty in the first part of page 5. Treaty means the revised Treaty of Chagaramas. And the definitions, to delete that, because it's going to be replaced with community or CARICOM, means the Caribbean community established Article 2 of the treaty and includes the CARICOM single market and economy signed at Nassau, the Bahamas on 5th of July, 2001.
Where's treaty?
It will replace, yeah, on page 4. It'll be on page 4. In the appropriate alphabetical order. In the appropriate alphabetical order. So I would delete, as I said, treaty means the revised Treaty of Chagaramas, and substitute that on page 4, but in the correct alphabetical order. Customs. It's customs.
Treaty is on page.
Treaty's on page 5. It is 1, 2, 3, 4 paragraphs down on page 5. So I'm deleting.
So this is the one that has the space. Does your 3A have?
So,
Look at 3A. Full space. That's the one wants the space, right? That's the one that wants the space. Which means it was to refer to the other. You're gonna mention it or you want to read it?
Yeah, just make the amendment. Yeah. I want me to read the amendment again? No. The amendment would read, reiterate, community or CARICOM means the Caribbean community established by Article 2 of the treaty and includes the CARICOM single market and economy signed at Nassau, the Bahamas on the 5th of July, 2001.
yeah, because you have the amended version already. Yes. It was distributed. You have it already.
I wish to suggest that you will also have to amend page 4 then. The third definition, CARICOM, will have to be deleted.
Third definition.
What? This is the first definition, right? So this was amended to read community or
This is the definition.
This is what is amended to.
Yeah, but then this has to be.
That's the only definition.
There's only one definition.
In fact, it's not a definition.
No, sure.
Unless he might be looking at the old one. Yeah.
Right. And the correct alphabetical.
Yeah.
Sorry. So with the amendment, I'd like to move that clause 2 stand part as amended.
The question is that clause 2 as amended stand part. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 3.
Mr. Chairman, I would like to move that clause 3 stand part.
The question is that clause 3 stand part. Honourable senators in favor, please say aye.
Mr. Chairman, if you can just make the amendment for line 4, JRRC space with.
Should have a space.
Yes.
This one doesn't have a space.
Yes, sir.
Space DRCC.
Yeah, that is noted. That space to be.
Thank you, Mr. Chairman.
Yes. The question is that clause 3 stand part. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 4.
Mr. Chairman, I'd like to move that clause 4 stand part.
The question is that clause 4 stand part. Honourable senators in favor, please
Mr.
say
Chairman,
aye.
if I may, the third line of clause 4, JRCs to share advanced passenger information with intelligence agencies. For purposes of formatting, instead of having it left just to the left, it should be justified so that intelligence falls properly with the sentencing. The sentence.
Say it again.
The drafting seems to be justified, but JRCC to share advanced passenger information with intelligence agencies seems to be to the left. So for consistency, it needs to be justified so that it falls properly within the framework of the section. Do you see that space between with and intelligence, sir? If it was formatted differently, it would fall just as how the lines before and after are falling. So instead of being justified to the left, it needs to be centered, justified.
Oh, the centering.
It was justified rather than to the left.
Yes.
Thank you, Mr. Chairman.
Noted. Question is that clause 4 stand part. Clause 4 stand part. Clause 4.
Mr. Chairman, I'd like to beg to move that clause 4 stand part.
The question is that clause 4 stand part. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 5.
Mr. Chairman, I'd like to beg to move that clause 5 stand part.
The question is that clause 5 stand part. Honourable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 6.
Mr. Chairman, I beg to move that clause 6 stand part.
The question is that clause 6 stand part. Honourable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 7.
Mr. Chairman, I beg to move that clause 7 stand part.
The question is that clause 7 stand part. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Report.
Mr. President, I beg to move that you now report to His Honour the President of the passing of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Honourable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passes in committee of the bill under consideration.
With amendment. With amendment.
With amendment.
Mr. President, I beg to move that the bill now be read a third time.
Question is that this bill be now read a third time. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it.
Mr. President, I beg to move that the bill do now pass and be cited as the Customs Amendment Bill Act, 2018.
Question is that
message
this bill do now pass and be so cited. As amended. I'm advised that this bill has got to go back to the other place, and so I want to amend. We can do this separately, though. When we come to this is the same bill. I'm sorry. I want to focus for a moment. I'm looking at something else that we have to come to in a minute. So I think the question is that this bill do now pass and be so cited. All honourable senators in favour of the resolution, please say aye. And those against, please say no. The bill is now passed and will be so cited.
Order number 18, in the name of the Honourable Leader, in the name of the Honourable Minister of Information, to move the second reading of the Immigration Amendment Number 2 Bill 2018.
Mr. President, I now move that the bill be read a second time.
The question is that the bill currently under consideration be read a second time. All honourable members in favour, please say aye. And those against, please say no. I think the ayes have it.
Mr. President, I beg to move that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of the bill.
The question is that I do now leave the chair. The Senate resolves itself into a committee of the whole Senate for the further consideration of this matter.
The Senate is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. Honourable senators in favour, please say aye.
Mr. Chairman, my document does not have a number. It just says this act may be cited as the Immigration Amendment Number Blank Act 2018. There would need to be an insertion, I believe, of the number 2. Mr. Chairman.
Yeah.
Thank you, Mr. Chairman.
Mr. Chairman, I beg to move that Clause 1 stand part with the amendment number 2.
No amendment. There's no amendment.
It's not amendment.
It comes from the other place. But you've got the bill.
Be number 2. They'll just put the 2 in it.
You don't know what bill it would be, number 1 or number 2, until it's actually passed. So the bill you're debating is a bill that comes from the other place. So there's no need to make the amendment.
The question is that Clause 1 stand part is with 1 or 2. Honourable senators in favour, please say aye.
Aye.
Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
The question is that Clause 2 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 3.
Mr. Chairman, I beg to move that Clause 3 stand part.
The question is that Clause 3 stand part. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Clause 4.
Mr. Chairman, I beg to move that Clause 4 stand part.
The question is that Clause 4 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 5.
Mr. Chairman, I beg to move that Clause 5 stand part.
The question is that Clause 5 stand part. Honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Report.
Mr. Chairman, I beg to move that you now report as honour the President at the passing of one bill in committee.
The question is that I do now report this honour the President, the passing of one bill in committee. Honourable senators in favour, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Chairman has reported to me the passage of the bill under consideration in committee.
Mr. President, I beg to move that the bill now be read a third time.
The question is that this bill be now read a third time. All honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this act do now pass and be cited as the Immigration Amendment Number 2 Bill 2018, Act 2018.
The question is that this act now pass and be so cited. All honourable members in favour, please say aye. Aye. Those against, please say no. The act is now passed and will be here cited. Thereafter cited.
Mr. President, I'd like to recommit to announcements.
Yes. We need to revisit the item announcement, as I have a message from the Honourable, the House of Assembly, to the Honourable, the Senate. And it reads as follows. The Honourable, the House of Assembly has the honour to inform the Honourable, the Senate, that on the 18th day of December 2018, the Honourable, the House of Assembly committed the following bill, Public Finance Management Bill 2018, to a joint select committee of the two houses, comprising 7 members of the Honourable, the House of Assembly, and 4 members of the Honourable, the Senate, and has approved the following terms of reference for the committee. Terms of reference: 1, to inquire into and determine whether the bill as drafted effectively fulfills the express object of improving the management of public finance in Barbados. 2, to examine whether the bill as drafted will, upon effective implementation, contribute to an ethos of compliance with the financial rules and government affairs, thereby promoting transparency and accountability. 3, to make recommended changes, if deemed necessary, to the bill as drafted for further consideration by the Chief Parliamentary Council. The House of Assembly has appointed the following members to the Joint Select Committee: Honourable Dale Marshall, Attorney General and Minister of Legal Affairs; Honourable Wilfred A. Abrahams, Minister of Energy and Water Resources; Honourable Colin E. Jordan, Minister of Labour and Social Partnership Relations; Honourable Kurt Humphrey, Minister of Maritime Affairs and the Blue Economy; Honourable Ryan Strawn, Minister in the Ministry of Finance; Mr. Ralph Thorne, Attorney at Law, and Bishop Joseph J.S. Atherley, Leader of the Opposition. And that message is dated the 18th of December 2018. To further advise that the following members from the Senate will form part of the Joint Select Committee. Senator Kay McConney, Senator Crystal Drake, Senator Althea Wiggins, and Senator Rommel Springer. That brings us to the end of our business.
Mr. President,
we have an adjourned date. The 12th. You sure that on Sunday?
Mr. President, still on announcements, minutes of meeting of Wednesday, 11th.
Sure the minutes are with us? I have to go back to a book that I haven't consulted for at least 9 hours now.
They said that they'll be taken as read and approved. See, real fair. Look, there's a note to you.
Yes.
Yeah, just move that they'll be taken as read and be approved.
I have the minutes of the meeting held on Wednesday, 11th of December 2018 that we confirm. And will someone move that be taken as read and Yes, will someone move that the minutes of the 11th of December be taken as read and approved?
Mr. President, I beg that the minutes be taken as read and approved.
Taken as read and approved, the minutes of Wednesday, the 11th of December 2018. Yeah, you got a second, huh?
No, you just...
Yes, so the minutes of the meeting held on Wednesday, 11th of December 2018, taken as read and approved, and they will be confirmed.
Mr. President, this brings us to the end of our business for today. It has been a long day, and I want to commend and also to thank all honorable senators for their participation and their support, because without their support, we would not have achieved the aim that we, in terms of dealing with these 22 bills before us, and I know that you all appreciate the urgency involved. Mr. President, before we adjourn, however, this being the season, I first of all want to say how I have enjoyed over the past 6 months the apparent camaraderie and as we engage in debates in this honorable chamber. Certainly enjoyed it. And I want to wish all of my colleagues, and yourself, Mr. President, of course, a most enjoyable Christmas. I know that all of us, I'm coming to that, all of us are religious, and I certainly hope that during this season, each one of us will find some time to attend your place of worship, and also bearing in mind the situation in Barbados, where several persons are now less fortunate than all of us in terms of having been displaced, that we will all find it within our hearts and certainly within our pockets to assist some person who is in need of help. I know that we will all be eating and making merry, but I caution you as a physician that I caution you as a physician in terms of moderation, especially in eating and more so in your drinking, recognizing that some of us have a lesser or greater capacity and tolerance in terms of those beverages. I also want to thank the clerk and the clerks and the staff at the table, the marshal and the deputy marshal, the members of the Royal Barbados Police Force, security, the clerical staff of Parliament, the caterers, and indeed the persons who make it possible in terms of the televising or interaction, even though sometimes I wonder if they listen, hear everything that is said in here in between sessions. I want to really thank all of them for the role they've played in supporting us over the past 6.5 months, and wish all of them a wonderful Christmas. And I look forward to seeing you all in the new year. I got another adjournment signing day.
Just before we have the adjournment, I just
Mr. President, I find myself agreeing with Honourable Senator Walker for the first time in his entirety in this period. So this is truly the season of miracles. I can associate myself with everything that he said, sir. And no, not the physician part, but I can understand that I'm a teetotaler. Sir, I want to wish every one of you the best possible Christmas, all the joys for the season and the new year. And I hope that we will be back here in the new year as wonderful as we have been in the last 6 months. I truly enjoy these sessions, and I'm looking forward to seeing you in the new year. And I don't agree with that. So, sir, without delaying the Senate much longer, I want to wish the Senate and all the people associated in making what we do here possible the most joyous holiday. Thank you, sir.
Before we bring our proceedings to an end,
Independent money.
Mr. President, on behalf of the independent senators, we wish you and all of our fellow senators a peaceful, a prosperous, and a restful Christmas and Happy New Year. And all of the support staff and all of those persons who work with us to ensure that our time spent in the Honourable House, the Senate, is productive and comfortable. Thank you, Mr. President.
Before we bring a closure to our proceedings today, I just want to thank all honourable members, the Leader of the House, Senator Franklin, and Senator Tate, for the expressions of goodwill and good wishes to all of us at this time of the year. I want to add my own sentiments of Happy Christmas to all of you. We did that earlier today at lunchtime, but it is useful to do it again. And I hope that we will come back in the new year. There is no dates at this point. Fully refreshed and recharged and ready to continue our good work here in the Senate. I want to say that I'm very proud of the performance of the Senate from the very first time that we came together as this Senate, and particularly today, notwithstanding proximity to Christmas and the many demands that are being placed on our time, the single-minded devotion and commitment today for the last 8 hours. It speaks well about us and for us. And I want to tell you that as the President, I'm very proud of all of you. Just want to remind that on Friday at 6:30, I think, there would be the unveiling of the plaque in honor of Dame, I'm forgetting her first name, Bourne, Dame Ermi Bourne, yes. And all of you are invited. The unveiling will take place here in the committee room next door, and you are all invited.
Mr. President, I now beg to move that the Senate be adjourned.
The question is that the Senate be adjourned before the day appointed. Sign the day. All honourable members in favor, please say aye. Aye. Those against, say no. You think the ayes have it? Happy Christmas to you all.
No.